Yes.
May I like to mention some typographical omission is there in the order dated 19.
But we won't get time to correct it. Mention after the eviction.
Tomorrow, my lord.
Tomorrow we are not taking up division.
Because then, my lord, at 2 p.m. Because
Very
your lordship directed that matter, my lord. The election.
Send it over, we'll issue a supplementary list at 2 p.m.
2
2
p.m.
p.m. we don't know whether this bench will survive till 2 p.m. because it will survive in a different sense. So, let it appear at 1. 1.
Seeking leave, my lord, your lordship was pleased to grant me injunction order, my lord, but there is no liberty to serve the server copy or obtain the server copy. But that's why the other side.
No, that's not it. Server copy is recognized.
That is not there, and the
Need
certificate.
not be there.
I applied for the certificate. I am not getting certificate copy.
No, server copy is sufficient. All the courts have instruction.
May I permit to mention for inclusion?
No, not inclusion.
Depositing special messenger cost.
We don't have any other. We don't have any other day before the vacation. Please call on the list.
After vacation.
No further mention. Thank you. Yes.
Lord, I am appearing for the appellant, my lord.
Yes.
Lord, I appear for the respondent number 1.
My lord, this is that matter, my lord, question of commercial division, and my lord, no case of established fraud and irrefutable justice.
We're not so sharp, Ms. Chakravarti. Just remind us.
My lord, if I may, my lord,
You're challenging an injunction order.
yes, my lord, ex parte ad interim injunction order, my lord, plaint, my lord, filed by the respondent, my lord.
They take your seat. We'll call up. Yes.
My lord, my lord, they have obtained an injunction order restraining invocation of performance bank guarantee. My lord, no case of fraud, my lord, established fraud made out in the plaint. My lord, no case of irretrievable justice also made out in the plaint. And my lord, it's a commercial dispute matter. It could not have been passed in the non-commercial division. So my lord, order passed without nullity. My lord, there are other, my lord, grounds.
Another ground was arbitration clause is there, you say.
Yes, my lord. Arbitration clause, exclusive jurisdiction clause in
But
Jamshedpur.
arbitration clause per se is not a bar.
My lord, that's the reason I am only pressing for 2, my lord, for that, my lord.
Well, let us hear Mr. Dev.
My lord.
Yes, Mr.
Lord, what is the suit for? The suit for non-encashment of the fee bank guarantee. Lordship kindly come to plaint, my lord, prayer. Page volume 2, page 132 to 138.
What sort of a plaint is this, Mr. Dev?
My lord,
What sort of a plaint is this? You are seeking for an order.
Lord, this has come from the citizen.
Obviously, you have not drafted. Anyway,
Definitely.
the order declaring that there is no claim of deficiency.
138 page.
130, yes, we are reading that. So, no deficiency, no claim of deficiency in the transformers such and such. Transformers are always repairable during the warranty period.
Lord, there is no dispute between the parties.
Cannot attach. If there is no dispute, we'll hold we'll reject
They
the
have
plaint
made-
on that ground.
They have paid the full amount.
If there is no dispute, there is no cause of action for this. We'll reject on that ground.
No, they have filed an application for encashment of the bank guarantee. And what the bank guarantee clause contains, that I shall place before our lordship.
That itself, it's a dispute, Mr. Dev.
That is a dispute, but there
Unless there was a dispute, you don't have any cause of action for the suit.
today, my lord, they have
Must have raised a dispute regarding your not performing. And you have sought for a
there is
declaration.
no letter. There is no letter that there is.
So why did you seek this declaration in the first place then? There is no cause of action for the suit. Well, non-disclosure of cause of action is good ground. At any stage, we can reject the plaint. But rejecting the plaint then?
No, lordship kindly do not do this.
Why not? You are saying no cause of action, we'll record that and
Lord,
reject.
my lord, there is no cause of action. I say, my lord, there is no dispute between the parties. They have
Dispute
paid.
is a cause of action in a suit, Mr. Dev.
Only thing is, my lord, they are trying to encash the bank guarantee.
Please come to para 7 of your plaint.
Paragraph
17, I'm sorry.
17.
Yes. Page 136, para 17 of your plaint.
Yes. That the cause
You
of
have stated
action
about a cause of action.
for the arrow suit being recurring on lastly arose on such and such 13 March 2026 in the aforesaid bank guarantee in the bank branch of the defendant bank and such branch when the defendant.
You say there is no dispute.
I say dispute regarding the materials what I have supplied. The transformers. We have supplied the transformers. They have not raised any objection that the transformers are not functioning.
But isn't this purely a commercial dispute? A commercial court sector.
In that even lordship.
Yes.
Transfer over the appropriate bench, my lord. That can be under section 20.
Not bench. The suit has to be filed in that manner. 12A comes in.
Yes.
12A is a bar. 12A is a clear
But
bar.
to tell you, Lordship, Lord,
You have to
even
plead urgency,
till
12A.
today, my lord, that civil court is accepting this type of suits in the regular
No,
bench.
city civil court has commercial determination as well as normal
Yes, yes,
determination. So it's how you couch your suit that the provisions of Code of Civil Procedure in normal courts or as amended by the Commercial Courts Act applies. So it's a different paradigm altogether, Mr. De. For commercial, you know that commercial suits and normal civil suits. It's a different paradigm.
Yes.
Apart from 12A even, summary nature of the procedure and other things are there. So to avoid that, you cannot file a regular suit. It's palpably barred because if you come to the definition of the commercial dispute, Mr. De, please.
Section 2(1)(c), commercial dispute means
C,
a dispute arising out of, if my lord kindly sees, 18, Roman clause 18.
Yes.
Agreement,
Right, right.
sale of goods or provision of services.
Arising out of is quite wide.
But what I
This is arising out of a dispute of
what I am
agreement.
trying to say, my lord, they are fraudulently trying to encash the bank guarantee. Since they have
No,
paid,
the suit is not maintainable before an ordinary civil court.
that I understand.
That's a great difficulty.
But kindly, Lordship,
And Mr. De, there is no fraud alleged in the parent contract. That is the consideration because this is an independent contract and the bank has to oblige.
but I just place only 3 agreements regarding the encashment of the bank guarantee.
No, yes,
That is, my lord,
yes.
page 147. Volume 2. It starts from page 146. This is a all
Parent contractor agreement এটা settled exceptional case exceptional case শুধু না parent এটা fraudulent সেটা দেখাতে পারলে তখন মেরুদণ্ড ভেঙে গেল মেরুদণ্ড ভাঙলো ব্যাংক গ্যারান্টিতে ইনজাংশন হয় না যে দেখতে হবে অন্তত 1000 কোথায় জাজমেন্ট আছে yes
page 147, my lord. That starts from this is performance bank guarantee.
what is the difference
Performance bank guarantee whether the
if you don't perform the bank guarantee will be invoked if it's a service contract it's a performance bank guarantee
performing regular, there is no difficulty.
bank guarantee performance bank guarantee this is between the bank and you
Kindly come to page 150.
bank assures them that they'll pay the money if they invoke
But no money is due.
so that is your case
That is your case. They have not made any complaint that machine is not functioning. Where
That is not correct. That is not
there is not a single whisper. There is no mail. Lordship, kindly come to page
all the
150.
mails are suppressed by
The second paragraph, the payment to the supplier as aforesaid in accordance with the terms of the order, the guarantor hereinafter agree and hereby irrevocably guarantees that in the event of the equipment supplied
you have just read it
yes, irrevocable.
you have just read it
failed to perform. This machinery is failed to perform. This is not their case. The same point in all the other 2 bank guarantees. How they can encash the bank guarantee?
bank guarantee injunction cannot be granted
And there also I am also relying on a judgment.
please absolutely definitely will rely
That is reported in 1988 1 Supreme Court cases 174. And I am relying on the first paragraph.
first paragraph
The Arbitration Act 1940, section 41, where in a work contract bank guarantee executed by
first paragraph or head note
or the head note, sorry, head note,
acha
executed by bank on behalf of the
So,
contractor in
yes.
favor of the principal held. Court cannot issue injunction order, section 41 of the Arbitration Act, dated in section 1 and 2 of the injunction.
no what are you reading
But I am now reading, my lord, 41 of the Act and encashment of the bank guarantee, except in the cases of fraud.
no which portion are you reading
The head note part. First,
watch the
head note part. I was reading. head note.
works contract bank guarantees
It's not matching.
এই যে first paragraph, এই head note, this head note.
yes read the head note Mr. De. That is the proposition Ms. Chakravarti is citing also
Not Arbitration Act 1940, then my lord, where
no
in a-
where in a works contract bank guarantee executed by bank on behalf of the contractor in favor of the principal held court cannot issue injunction under section 41 there because you are relying on this it was section 41 read with such and such of order rules 1 and 2 of order 39 also restraining the principal from invoking and encashing the guarantee So you cannot cannot grant injunction except in cases of
Yes.
fraud or apprehension of irretrievable injustice to the
That
contractor.
is my case.
By definition, what Ms. Chakraborty also submitted.
That is
You have
my
not
case.
made out a case of irretrievable injustice.
We shall suffer, my lord. We shall
No,
suffer. But we have given back.
On both grounds, the injunction is bad. Commercial court as well as
That may I suggest one thing, lord.
you cannot suggest anything. You can file a regular commercial suit and get your injunction.
Lordship, can you protect me for at least for a week?
No. No.
Otherwise, lord, the injunction, if goes, they can encash that. We shall.
They will. They are entitled. You will be entitled to recover that money and add a relief to your suit.
For that, my lord, we are
Bank
ready.
guarantee is the third
For
agreement.
that, we are ready to put security deposit of the entire amount.
Bank guarantee is that security. Let them take it. This is the bank.
This is there in their hands. If they apply to the bank, then if the bank gives money, then my lord, will be seriously prejudiced.
No.
But it kindly protect some interest, my lord, some.
By the impugned order. Acha. ওটা extra হয়ে যাবে ওটা even beyond their prayer.
Lordship, kindly do some protection. Give us protection, my lord, we shall be. Because we are not at fault. There is no complaint, nothing. The machineries are functioning regularly.
Yes,
They have paid for the.
Pages 47 onwards. My lord, and my lord, pages 47 onwards, thereafter pages till 66. All my lord letters of dispute. My lord, the power transformer that they have my lord, supplied on us, my lord, firstly there was delay in supply. And my lord, the contract says that essence of the contract, well, time is the essence of the contract. They had to supply within the time. They did not supply within time. And the power transformer supplied was also defective. It was stripping. There was operational disruption. There was seepage. And my lord, not only that, my lord, what has happened? There was abnormal temperature rise
Lord,
with
for
regard
that,
to the
my lord,
power
For
transformer.
that, will
My
Lordship
lord,
allow us.
this is one
They have
letter.
raised a dispute from your letter.
That will Lordship allow us to file some written objection to those.
Suppressing the plaintiff.
It can be decided on affidavits, my lord. That on the first statement I submitted.
No, that's the reason I'm only pressing for my
You
lord,
said there is no dispute raised by them. Your series of letters annexed by you show the dispute.
In the trial court,
and
the
that is
injunction
vis-a-vis the first contract.
order was passed the ex parte. So we had no occasion to
Now these documents were not there before the trial court.
Not there.
No,
not
that
dispute,
is the whole-
suppressed.
suppressed or Lordship kindly.
My lord, this is how, my lord, they have shown that there is no objection to the work performed by them. My lord, these are the
The
letters.
trial
vis-a-vis
court can
the
hear
first
the matter on
contract.
merits, my lord. That is my suggestion, submission, my lord.
Learned
Trial-
counsel for the present challenge appeal has been preferred against an order of ad interim injunction restraining the defendant stroke appellant from invoking three performance bank guarantees furnished by the plaintiff stroke respondent. So next para, learned counsel for the appellant contends that the suit, as evident from the plaint, pertains to a commercial dispute, and as such, the learned trial judge, sitting in ordinary civil jurisdiction could not have entertained the same, which hits at the very root of the prima facie case for grant of injunction. So next para, secondly, it is argued that it is a settled proposition of law that injunctions in respect of invocation of bank guarantees are not readily granted unless a case of fraud or apprehension of irretrievable injustice is made out in the context of the parent agreement between the parties. For some next para, it is contended that the dispute pertains to the service to be provided by the plaintiff stroke respondent in respect of transformers. Full stop. It is argued that while obtaining the injunction, the plaintiff stroke respondent suppressed several complaints registered by the appellant with the plaintiff stroke respondent by way of emails and other communications relating to the delay in such performance as well as in the several deficiencies in respect thereof. Full stop. Next para. As such, it is argued that the learned trial judge erred in law in granting injunction. Full stop. Next para. Learned counsel appearing for the plaintiff stroke respondent submits that in the City Civil Court at Calcutta, uh, both commercial and regular civil suits are filed. Full stop. Next para. As such, there it cannot be said beyond doubt that the impugned order was passed sitting in ordinary civil jurisdiction. Full stop. Next para. Secondly, it is argued that in the event the performance bank guarantees are invoked, the appellant, the respondent will suffer irreparably. Full stop. Even otherwise, it is submitted that, as pleaded in the plaint, there is no dispute on the substance of the agreement of supply of such service. Full stop. As such, it is argued that the invocation of bank guarantee, if permitted at this juncture, would not only be contrary to the contract between the parties, but also create irreparable injury for the plaintiff stroke respondent. Full stop. Next para. Upon perusal of the plaint of the suit from which the present appeal arises, we find that although the suit has been valued only at rupees 100, the same squarely pertains to claims of deficiency in the transformers, substations and other machineries supplied by the plaintiff. For next para, it is quite obvious that the valuation of such transformers stroke service would much exceed the specified value as stipulated in the Commercial Courts Act 2015. So next para, in terms of section 2 within bracket 1 within bracket small c within bracket Roman 18, disputes arising out of agreements for sale of goods or provision of services, it comes within the ambit of commercial disputes. For next para, it is to be noted that the paradigm of commercial suits is entirely different from ordinary civil suits, in view of the provisions of section 12 capital A in a commercial suit being mandatory, and also the summary nature of the context of a commercial suit as opposed to a regular civil suit. From the plaint itself, it is clear that the suit has not been couched as a commercial suit. Next para. Thus, the learned trial judge did not have jurisdiction in ordinary civil jurisdiction, did not have authority in ordinary civil jurisdiction, to entertain the suit or pass the ad interim injunction. So next para. Secondly, from the four corners of the plaint, we do not find any specific allegation that the parent contract from which the performance bank guarantees emanate were vitiated by fraud or any irretrievable injustice with regard thereto. Next para, learned counsel for the appellant cites UP Cooperative Federation Limited versus Singh Consultants and Engineers Private Limited, reported at 1988 1 SCC 174, where it was reiterated in the context of Section 41 of the Arbitration Act 1940, as well as Order 39 Rules 1 and 2 of the Code of Civil Procedure, that court cannot issue injunction restraining the principal from invoking and encashing the guarantee, except in cases of fraud or apprehension of irretrievable injustice to the contractor. Next para, the said proposition is based on the premise of the very concept of a bank guarantee, which is an independent agreement between the concerned bank and the person in whose favor the bank guarantee is issued. Next para. Thus, the learned trial judge, without referring to any such fraud or vitiation of the parent contract, could not have granted injunction at the drop of a hat mechanically in respect of invocation of performance bank guarantee. Full stop. Hence, comma, the impugned order is bad in law on such count as well. Full stop. In such view of the matter, comma, the appeal is admitted and allowed on hearing the parties, comma, thereby setting aside the impugned order impugned order dated March 23, 2026, passed by the learned judge, 7th bench, City Civil Court at Calcutta, in title suit number 624 of 2026. Full stop. Consequentially, can 1 of 2026 is also dismissed. There will be no arrest to cost. Urgent certified copies.
What what will happen to my suit? That is the whole question.
Next.
But that judgment, my lord, I have referred. Lordship said the appellant referred.
Appellant বলেছে বোধহয় respondent. Learned
Respondent
counsel
number
for the
one.
respondent number 1.
Good.
Thank you. Judgmental reference যেখানে বলেছি cited by plaintiff stroke respondent number. Thank you.
Lord, item number 2, we appear for the appellants. My lord, I have checked up the file of your lordship's court, my lord. The file suggests that the appellate decree of the appellate court has not been filed, although the valuations has been, my lord, taken care of by the department
No,
itself.
the appellate court has not been filed.
Yes, decree of the appellate court is not has not.
That's a
been.
defect.
Yes.
With the judgment, you can file no
Yes,
litigation.
yes, yes. That has been taken care of. I have checked up the
So,
my lord.
you are to
stamp.
file only now the certified copy of the decree.
Yes, and
Unless that is filed, the valuation and the other calculations
and with regard to the delay part, my lord, we have taken out the application for condonation.
it is appearing in the list.
Yes, my lord.
Serve copies of that and
My
it
learned
will-
friend is appearing. We have served them.
So it's change brief lords. Yesterday you have received the brief lordship from the earliest Marshal and advocate.
yesterday is sufficient for a section 5 appeal.
Lordship,
Yesterday 24 hours, not even 24 hours.
it was already
How
dismissed.
long does it take to go through that? We do it every day in court.
Lordship, it is
You can do
dismissed. The main appeal is dismissed for default
No, no,
lordship.
it was restored.
953 days lordship. That was restored
It
lordship.
was restored
After
by a
953
coordinate
days
bench.
lordship.
Be that as it
No,
may,
it
my lord,
has been restored already.
Yes, my lord. It has been.
Also dismissed.
You cannot reopen that
Sorry.
one.
And lots of similar cause of action lordship already lordship in the West Bengal Land Reforms Tribunal lordship. There is an application was pending by my learned friend.
No, you cannot have a right of hearing at the order for stage.
Yes.
But you have to file the decree. Otherwise,
Yes, my lord.
the nature of
The only difficulty is we are
So at
facing
that-
an
at-
execution
at-
proceeding. That is the.
what can be done?
Yes, yes, I understand that.
Since no decree, no certified copy of the first appellate court's decree has been filed, comma, the matter is adjourned till after the upcoming summer vacation of this court. Full stop. The appellant shall file such certified copy at the earliest.
May it appear on the
It will remain in the list.
grateful.
Thank
See, my lord, in this matter, I am appealing for the plaintiff appellant.
Yes.
A suit for declaration injunction lost both the courts below. If you lordship
Plenty.
and the plaintiff appellant. If you lordship can turn to the suit for
Declaration of your title, usual title too. That-
yes, yes.
Achha.
The trial court dismissed the suit on
Yes.
the ground that it held that prior to filing of the suit, I have transferred the entire property in favor of my son. And that is the ground that on the date of filing of the suit, I do not have a right and interest over the property, and suit was dismissed. Well, can you turn on this court, my lord, can you consider the internal page? Four of the trial court judgment.
Yes.
Previously, the suit property belongs to my mother-in-law, but before her, I cannot say who is the actual owner. I have some landed property in Moja. My wife gifted property to my son. But kindly consider this is the page 4 of internal page for the trial court judgment.
Yes, yes. Please continue.
My wife gifted the property to my son. Before institution of the suit, the said deed was executed. So this was the submission made, my lord, on the basis of which the suit was dismissed.
No, so you say that previously suit property belonged to mother-in-law.
No, mother-in-law.
Mother-in-law first, then wife obtained the property through a Hibanama.
Yes.
So you never got title to the property.
No, I am the wife who buy a given number. According to the my wife gifted the property to
your
my son.
husband, very good, yes.
My wife
Why gifted the property to the son? So on the basis of this,
Yes.
right?
Now, my lord, can I turn to the findings of the appeals court on this court? If your lordship can turn to page internal page 5 of the appeals court judgment.
Yes, 5.
I have perused the record, my lord, got it.
উনি পড়ে গেল, হ্যাঁ? Yes.
I have perused the record.
When? Peruse the records? Yes.
Cell deed such and such, executed by Rojina Khatun in favor of her son Abdul Aziz, such and such. Source transfer 2 shatak of land out of 51 shatak.
Yes, which page? Page internal?
That is internal page 5 of the appeals court judgment, my lord. Now, my lord, can you turn to the ultimate finding of the appeal court, internal page 6, illustration after that.
But page 5 also, the only question is whether Hebanama can alone confer title.
Yes.
Page 5 also.
Yes, yes, yes. That is why, my lord,
No.
that is why, my lord, can you turn to page 6? Here in this case, my lord, you'll find that was discussed. So that is why I
No. Acha, very well. Let's illustration.
after illustration.
Yes, after that.
Here in this case, my lord, you'll find the plaintiff Rajina Khatun failed on stipulated ground. Firstly, she failed to establish by clinching proof that her mother was the actual owner of the suit property. Secondly, she failed to prove that defendant legally is not Borgadar and is not in possession of the suit property. Thirdly, she failed to prove that she was the owner and possession of the suit property at the time of filing of the suit in question. Pause there for a moment. Now, my lord, these are the 3 categories which I mentioned. First, she failed to establish clinching proof that her mother was the actual owner of the suit property. So, there from the reader statement, it is not disputed by mother was the owner. But I filed an application under order for rule 27 because it is not there. From the vendor of the mother, all the chain deeds I have annexed, my lord. It is not there. I have filed an application under order for rule 27.
File that in the appeal court.
That we did at that relevant point of time, it has not been
Disputed.
The trial
The appeal
court
court also did not hold that mother.
mother is not there. It is a clinching proof. If there is no dispute, the trial court proceedings, there is nothing on that score. Next is that, my lord, she failed to prove the defendant Liaquat Ali is not Borgadar. So Borgadar is, my case is that he is not the Borgadar. If somebody claims to be the Borgadar, he has to seek reference under order.
No proof of Borgadarship has been.
Nothing. No document has been proved.
Rights.
Nothing.
What were the exhibits?
No exhibit has been done by the, can you turn to page internal
So
page
did
4?
No exhibit ABCD.
No, can you turn to page 3 of the trial court judgment?
Yes. Yes, only your exhibits. The finally published Taylor records in the name
All filed by us. The defendant, the process
Rakia Khatun was the mother or
yes, Raja,
mother-in-law?
mother-in-law. So, if minor can consider trial court procedure, whether he is the Borgadar or not.
And
So-
third point is partially sold, partially gifted to son.
Yes.
So at least regarding the rest portion, title or
It's the title, even if minor, then are entitled to get joint position. If that is the ground, my lord, if I could not prove my entire title in its entirety, then
or
I
you might have lost on the injunction degree.
injunction degree.
But declaration.
But that declaration I am entitled to get and injunction joint position. It can mold. I am entitled to get joint position if that be so.
The second appeal, this second appeal will be heard on the following substantial questions of law. 1, whether the learned first appellate court substantially erred in law in proceeding on the premise that the predecessor in interest of the plaintiff stroke appellant, in bracket, her mother or her mother-in-law?
Her mother.
Oh, her mother, because her mother, bracket closed, was the actual owner of the suit property, comma, in view of the title of the such predecessor having not been disputed by the defendant in the suit, and since from the exhibits from exhibits 1 and 2 produced by the plaintiff stroke appellant in the trial court, comma, it is evident that the name of the said predecessor of the plaintiff is seen from the records of rights. Question number 2, whether the first appellate court substantially erred in law in holding that the plaintiff stroke appellant had failed to prove that the defendant is not a borgadar and is not in possession of the suit property, comma, by overlooking the records of rights exhibited in the trial court, as well as the fact that the defendant stroke respondent never proved his borgadarship by any cogent evidence whatsoever. Third, whether both the courts below substantially erred in law in refusing to declare the title of the plaintiff stroke appellant, at least in the portion of the suit property which was not gifted by the plaintiff stroke appellant in favor of her son, comma, in view of the findings of the first appellate court clearly establishing that only a portion of the suit property was the subject matter of the gift deed, hibanama, executed by the plaintiff appellant to her son. Yes, what any interim relief?
Yes,
Injunction.
that's a paper, and there is no reference also sought for by the defendant for referring, because if there is a borgadar dispute, then
That comes later. We will
Yes.
find it.
an application for injunction, my lord, and another application order for
No dispute has been raised. How can be?
No, my lord. If I claim my right to
If
now,
there was a dispute,
yes, then it is
that's why
required.
we were not formulating that as a question.
No, no, that is
So what injunction is? Sir? Dispute.
not to
Possession we are not granting.
no. I'm not to transfer.
But you are asked for only
That is the main thing.
only possession you asked. From causing disturbance in peace.
Status quo, my lord, as on this day, my lord,
You asked for only possession.
position. Because it is not disputed that I am not in position. Be as it may, my lord.
No. Portion of the property defendant. Your case is the defendant trying to disturb. Where your status quo as regards possession would be risk.
May I serve
Ask for any other injunction.
not to because he is claiming to the borgadar, so that is why I did
We
not.
did anything regarding transfer, alienation. There is a finding as to possession by the court trial, by the courts. Rather, if the finding is against you.
Yes. Yes, Sabre, my lord, there is nothing on record to suggest that. Paragraph 30. Peaceful position.
Since the question of possession is somewhat disputed, comma, we are not granting an injunction in respect of possession at this stage. However, comma, the grant of injunction at the final hearing of the injunction application is kept open, subject to affidavits. The petitioner shall serve a copy of Can 2 of Can 1. What was Can 1?
Can 2, my lord, Can 1.
Can 1 was what?
Can 1 take there's section 5 what is allowed.
Acha. Serve copies of Can 2 of 2025 and Can 3 of 2026 on the respondent, indicating that the applications shall be listed after the time frame for filing of affidavits is over, before the learned single judge then having determination. So next para, the respondent shall file his affidavits in opposition to both the applications within June 19, 2026. Reply, if any, shall be filed by July 3, 2026.
Well, the order for 26 applications.
The plaintiff shall file, the appellant shall file an affidavit of service at the time of on the next date of hearing. Can 3 of 2026 shall be listed for hearing. Can 3 of 2026, comma, being an application for production of additional evidence, comma, shall be heard along with the appeal.
For me, Lord, I am for the petition.
Yes.
My injunction application rejected me, Lord, and my injunction application rejected me, Lord, on the ground that I have failed to produce the chain deed, and my Lord, their vacating application has been allowed, my Lord.
Initially, you were enjoying an
Yes, initially I was enjoying the ad interim order, my Lord.
ad interim order of what? Status quo?
Ad interim order status quo, my
Suit
Lord.
is for declaration of your title.
Yes, my Lord. Suit for, my Lord, declaration, partition, and, my Lord, injunction, my Lord. Now, my Lord, Kindly come to the Milord, the impugned order. Sir. Milord, may I brief the history, Milord, first? Milord, originally, Milord, this property was belonged to Milord 3 persons: Golok Bihari Kha, Nimai Chandra Kha, and Jugal Chandra Kha. They are having 1/3 share of 2.66 acre of land, Milord. Now, Milord, thereafter, Milord, this Golok Bihari Kha gifted his share, entire share, to his 2 sons and 1 grandson. Thereafter, this grandson gifted his entire share to Jugal Chandra Khan. Thereafter, this Jugal Chandra Khan gifted his entire share to Subhash Chandra Khan. That is the main issue, Milord.
Who is Subhash?
Subhash Chandra Khan, Milord. Subhash Chandra Khan is, Milord, my predecessor.
So he's not one of the sons or the grandsons, that those
No.
three people.
Milord, this Subhash Chandra Khan, legal heir, Milord, sold 23.07 decimal of land to me.
23.07
decimal of land.
Achha.
This Subhash Chandra Khan, during his lifetime, sold some properties to the defendant number 1 and
Who is the defendant number 1?
defendant number is Santosh Kedia.
Completely different. Very.
Yes, Santosh Kedia and Gita Bauri. Milord.
So Subhash sold some of his property to the defendants.
Entire property sold to the
Defendant number 1.
Defendant number 1.
Defendant number 1 and the Gita Bauri, Milord.
Gita is not a party here.
Gita is not a party here, Milord.
Very well.
Then, Milord, this Subhash Chandra Khan, Milord, legal heir, Milord, intend to sold remaining portion of land to me, Milord. Prior to purchase of this property, Milord, I made paper publication. At that point of time, Milord, no objection was raised, Milord. And also, Milord,
Before selling this 23.
Yes, Milord.
07.
Yes, Milord. I made paper publication. I gave letter.
So nobody came and purchased.
Nobody came. Nothing.
You must have conducted search.
Yes,
Search
Milord.
is to
I have conducted search, Milord.
So
It is, Milord, I have that porcha, Milord, with
No,
me.
why was it vacated then?
Milord,
From
vacated,
their sale
Milord.
deed, it is seen that their sale deed is prior to your sale.
Yes, they are
So
selling.
that shows that the entire property of Subhash was transferred.
Yes, Milord. But Milord, no, Milord. That is the incorrect, Milord. They have enhanced their share, Milord. They have purchased one property. Now thereafter they have managed the LR department and they have enhanced their share, Milord.
They have a deed.
Milord, I have the porcha, Milord.
Don't get excited. They must have a deed.
Yes, Milord. They have deed. I am not denying their title, Milord.
Porcha prevails over deed.
No, Milord. Porcha does not prevail over deed.
To
But
yourself.
I have the Milord. I have the registered deed, Milord. It is
Your registered deed is subsequent to this.
subsequent.
From their registered deed, which is prior in point of time and registration, it is seen that the property which you have purchased was already transferred to this.
Already transferred.
You don't
According
have
to
a
them,
prior
Milord.
case. It was
Milord,
this
kindly-
was suppression, so it was vacated rightly.
No, Milord, kindly come to the Milord impugned order. Kindly come to the Milord.
Yes, before the ordinary portion, the second last paragraph.
Yes, Milord. Prima facie, I do not find any jointness of
So
title.
before that, the
pertaining to-
paragraph before that, please.
Fair. So it is very clear to this court, Subhash Chandra Khan during his lifetime has transferred his total share in respect of suit property measuring about 130 decimal by way of 2 registered deed. Therefore, the transfer made by the legal heir Subhash Chandra Khan in the year 2022 is not valid in the eye of law. At the time of transfer, legal heirs of the Subhash Chandra Khan has no valid title with them.
Precisely, next paragraph says what we say.
Yes, Milord, that is the joint.
Records of
I have-
confer title.
Yes, Milord. But Milord, I have the title, Milord. I have the deed, Milord. Even though, Milord, they have not challenged my deed. Even still now, they have not preferred any cancellation of deed, Milord.
No title passed.
I
You cannot
have the
get an
title.
injunction on the strength of that deed. You are the plaintiff.
Milord, I have the title, Milord. Milord, kindly see, Milord. Once, Milord, kindly see my title, Milord. Once, Milord.
Your deed gives you the title,
Yes,
but
Milord, I
that
have
is
the
a
deed, Milord.
subsequent deed. Before that, the title was given to you.
But-
I sell something to X and then sell something to Y. Y doesn't get a title.
But Milord,
Why we have a valid deed?
he has the I am not denying his title, Milord. But remaining, Milord,
He has
even
the
if-
title, you have the deed.
I have but even though, Milord, I have the Subhash Chandra Khan has share in his property, Milord. Subhash Chandra Khan in his share in his property, Milord. They have enhanced his share, Milord.
It's clear finding entire property was sold.
They have
Or 130
manufactured the LR record also, Milord. They have manufactured the
Those
record also, my lord.
ELR record is not relevant at all.
But, my lord,
We are not relying on the ELR records.
130 decimal of land sold 2%, Gita Baudi and Santosh
Nothing
Media.
remains to be sold to you.
Thereafter, my lord, 23.07 decimal is still there, my lord. That has been sold to me. I have searched the record, my lord. They have not placed for any objection before purchasing of the property,
The
my lord.
present appeal has been preferred against an order whereby the defendant's application under Order 39, Rule 4 of the Code of Civil Procedure was allowed, vacating an injunction, an ad interim injunction order obtained initially by the plaintiff stroke appellant. So the next para, learned counsel for the appellant submits that one Subhash was admittedly the owner, an owner of the suit property, having derived title from Jugal, one of the original co-owners. First up, the legal heirs of Subhas, after his demise, sold the suit property to the plaintiff stroke appellant. First up, prior to such purchase, the plaintiff conducted searches as well as made paper publications to which nobody responded. First up, as such, being assured of the title, the property was purchased by the plaintiff. So subsequently, the defendant set up a plea. Defendant number 1 set up a plea that he had purchased the property, the entire property of Subhash prior to the transfer in favor of the plaintiff stroke appellant, amounting to 130 decimals of property land. For next para, learned counsel submits that the defendant number 1 stroke respondent number 1 has manipulated the authorities and allegedly tampered with the records of rights. First of that apart, it is submitted that the registered title deed at least prima facie confers title in favor of the plaintiff stroke appellant. First up, as such, it is contended that the interim order of injunction could not have been vacated. First up, next para. However, upon a perusal of the impugned order, we find that the learned trial judge came to a clear finding that Subhash Chandra Khan, the grand predecessor in interest of the plaintiff stroke appellant, during his lifetime, had transferred his total share in respect of the suit property, measuring about 130 decimal by way of 2 registered deeds. First up, it was further observed that therefore, the transfer made by the legal heirs of Subhash in the year 2022, within bracket subsequent to the earlier transfer, bracket closed, in favor of the plaintiff is not valid in the eye of law because at the time of transfer, the legal heirs of Subhash Chandra Khan had no valid title with them. First up, next para. Hence, since such fact was not disclosed in the injunction application, it tantamounts to a material suppression, vitiating the ad interim order. Full stop. Next para. The learned trial judge also was justified in recording that the entries in the LR records of rights do not confer any title, being pitted, PITTED, against a prior transfer deed. For next para, we do not find any illegality in the impugned order. Full stop. Accordingly, is FMAT 254 of 2025 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, Can 1 of 2025 is also dismissed. No address of cost service. We tried very hard, but sorry.
Great.
Next.
But my appeal, matter, there's a delay of 75 days in preferring this appeal. I've filed my Section 5 application. I've tried to explain, matter. I can give the dates if it deems fit.
So, Patori, if he has a good case, then ask for affidavit, sir. If he has a bad case, don't.
73 days delay, my lord, in
Should be
preferring the
condoned.
appeal, my lord.
He has a bad case then. Very well. What is the explanation? We have to be satisfied also.
Right. This
Defect আছে? অন্য defect remove হয়েছে।
I should also point out there are other respondents. I am only for respondent number 1 and
In any event, then you have to serve on.
But if
Directed to serve. You have to.
I'll serve only thing when it comes to my stay application, I would require a supplementary affidavit. The section 5 attached has been wrongly. It is of some other case.
We are granting you that leave and we will direct you to serve both the applications on the other respondents. Mr. Patori, you are appealing for which?
Only for 1 and 2, my lord. Respondent number 1 and 2.
1 and 2.
And I'll
So you have got a copy only of the section 5.
Section 5 application, my lord, I have been served. My lord, one thing I would like to submit.
Yes.
That I would request my learned friend to also file section 5 application to the order 9 rule 13 application which they have presented.
I'll do that along
Why are you
with
advising him?
My lord,
Why are you advising him?
because the section 5 application which they have filed in their application.
They were there before the learned court below. They
Section
have
5
it in it.
application which they have annexed stating to be section 5 application respect to order 9 rule 13 application.
That is why I was praying for a supplementary affidavit. That is why I was praying for a supplementary affidavit.
Well, on the prayer of learned counsel for the appellants, leave is granted to the appellants to file a supplementary affidavit to the section 5. Stay.
No, to the stay, my lord.
To Can 1 of 2025. First of next para, copies of the said supplementary affidavit, advance copy of the said supplementary affidavit shall be served on the learned advocate appearing for the court, appearing respondent numbers 1 and 2. You have not got a copy of the stay application.
I have got the copy of the stay application.
Okay. Full stop next para. The appellants shall also serve copies of Can 1 of 2025 as well as Can 2 of 2025 along with the aforesaid proposed supplementary affidavit on the other respondents being respondent numbers 3 to 10 and file an affidavit of service in that regard on the returnable date. Full stop. The application shall next be listed for hearing. The applications shall next be listed for hearing under the same heading. The matter shall next be listed for hearing under the same heading in the monthly list of June 2026.
Grateful. Deeply obliged.
Hello, is it? Yes.
As I said on the last occasion, I'll be very brief.
Mr. Rai has briefed you.
But he's there with me to assist.
No difficulty. Mr. Banerjee is also briefed Mr. Thakur, so equally balanced. And there's nothing in either of your cases. So yes.
But
Yes.
I lost in both the courts in a suit for recovery of possession on the ground of a flux of lease in respect of a petrol pump property.
Very good starting.
My opening says it all.
Why were you briefed? Someone more.
No, there's only one. The point is, here, we took out 2 applications, for additional evidence before the first appellate court. The first appellate court was obliged, to apply its mind as to the necessity and the content of the additional evidences which I propose to bring forth. But that was never adverted to by the appeal court. This is a procedural irregularity by the appeal court, of which the additional documents I wanted to adduce were the post this 2001 Act. I have filed Form A and the TICA controller is in session of the matter by issuing notice for a determination about the status of the land as a TICA property. That is one. Another important document, what I wanted to bring forth before the court was that a notification under the West Bengal Town and Country Planning Act, which prohibits change of user in respect of those lands which are used for as petrol pumps. These 2 are important because of the notification which has been issued. Even if my learned friend gets back the possession, they cannot use it for any other purpose because the notification is still in force according to me. So, the first appellate court
preempt that we cannot anticipate that. Whatever they will use it as a petrol pump, maybe.
They may not because I am the
It's not
Indian.
German.
I am not the.
Because is that even German? How they will use it in future cannot be German for. They are getting an eviction degree right now on extra efflux of time.
I understand, what your lordship means.
And TICA tenancy, you have referred the matter to TICA tenancy. That's not even German because if that is referred ultimately held, then you can take your
restitution, whatever.
You know whatever you have.
Yes.
At this point of time, it has not been declared as a TICA tenancy.
এইটা যেটা additional evidence 5.2 and 5.3 6 এর নোটিশ দিয়েছে not
Lord,
filed both.
if your lordship kindly takes a look into Lord the applications, Lord,
Was it in your pleadings that it's a ticket tenancy?
My lord?
Yes, 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 that is the
Was
case.
it in your pleading that it is a ticket tenancy?
Yes,
That is the main case.
It was decided by the courts.
decided by the court by reference to Lord the review judgment of Money Square, wherein Lord it was said that my witness came and said that there is a pakka structure, and Lord that Lord, Lord, that is I will not be arguing before your
That is
lordship
another ground on which Mr. Mukherjee that was not German. So non-consideration of those irrelevant order of Rule 27s, irrelevant not in a derogatory sense. But,
I say, Lord, it is a procedural irregularity on the part of the first appeal court, Lord, to not to advert. Lord, just kindly have a look into how, Lord, it was decided.
Suppose it was not dealt with. We are considering that and dismissing it.
That your lordship.
What will be the effect
can,
of that non-consideration? We can consider it.
I will, Lord, just rely upon one judgment before your lordship.
Please.
And Lord, kindly have a look into Lord the page 18 of Lord the appeal court's order. The second last page, starting from result.
Yes. Oh, consequentially 4127. It should have been the other way around.
Lord, he has to Lord apply its mind about the content. Lord, why I say this, Lord, judgment.
Oh, judgment.
Yes. But I was referring to 2010 volume 13 Supreme Court cases 487 paragraph 14 15 is not the relevant one.
Means into
What you submit that is the law of the land. এখন তো other side এ judgment হবে।
হ্যাঁ এখন তো বলে দিয়েছে সেগুলো নিয়ে আসি খুঁজে রাখো খুঁজে টুজে বার করি না এখানে দেখো দাদা 51525 না এটা ইফেক্টটা দিচ্ছে 82 থেকে সেই জন্য বলা after lease period and became expensive. This was
Mr. Mukherjee, we are giving you notice, we are putting you on notice. We will also refer to section 99 of the Civil Procedure Code, which says, apart from non-joinder misjoinder, no decree shall be reversed or substantially varied. We are culling out the portions which are relevant. You know, but still, no decree shall be reversed or substantially varied on account of any defect or irregularity in any proceedings in the suit not affecting the merits of the case or the jurisdiction of the court. We'll refer to this and say that not affecting the merits, we are accepting that. So on that ground, it should not be. You can argue, because even if it's a procedural irregularity, this is a very good, apt judgment which you have cited. But we'll have to deal with this. How you deal with your this? I think.
I'll not be disturbing you with other points, Lord, because I cannot sustain.
Thank you for that. The present second appeal has been preferred against a judgment of affirmance, whereby both the courts decreed an eviction suit filed by the plaintiff respondents against the appellant on the ground of efflux of time, on the ground of expiry of the lease by efflux of time, comma, within the contemplation of section 111 of the Transfer Property Act. So next parallel, senior counsel appearing for the appellant cites Malayalam Plantations Limited versus State of Kerala and another, reported at 2010-13 SCC 487, in arguing that despite two applications for production of additional evidence under Order 41/27 of the Code of Civil Procedure having been filed by the plaintiff stroke appellant before the first appellate court, comma, those were not even adverted to by the learned first appellate judge. The first appellate court proceeded to decide the appeal on merits and thereafter to consequentially dismiss the Order 41 Rule 27 applications, which is contrary to law. Full stop. In support of such contention, the learned senior counsel reiterates that in Malayalam plantations supra, the Honorable Supreme Court observed that it was not inclined to go into the validity or acceptability of the documents stroke materials filed by both sides before the High Court, and that Order 41 CPC speaks about procedure in respect of disposal of appeals from the original decree. First up, upon quoting Rule 27 thereof, it was observed that in view of the above provision, when an application for reception of additional evidence under Order 41 Rule 27 CPC was filed by the parties, it was the duty of the High Court to deal with the same on merits. First up, next para. It was further observed in the said judgment that if any application is filed under Order 41 Rule 27 in an appeal, it is incumbent on the part of the appellate court to consider at the time of hearing the appeal on merits so as to find out whether the documents or evidence sought to be adduced have any relevance to bearing on the issues involved. Full stop. Next para. Upon a perusal, learned senior counsel further argues that in one of the said additional evidence applications, the appellant had sought to rely on certain documents indicating that an adjudication as to whether the suit property is a Tika tenancy was pending before the Tika controller. First up, in the other a notification under the Town and Country Planning Act was sought to be brought on record, from which it would be evident that a property which is being used
Petrol pump or retail outlet, your lordship.
as a retail
Outlet.
fuel outlet.
Retail, they call it retail outlet. Petrol
Retail,
pump.
retail, thank you. Retail outlet cannot be converted to some other use. Full stop. Next para. Upon a careful consideration of the proposition laid down in Malayalam plantations supra, we find that the plinth of the proposition laid down therein pertains to a consideration by the court as to whether, if the documents or evidence sought to be brought on record as additional evidence, would have any relevance or bearing on the issues involved. Full stop. Next para. It is also well settled that merely due to a procedural irregularity, an appellate court does not interfere with the decision of either a first appellate court or the suit court. Full stop. Section 99 of the Code of Civil Procedure provides, inter alia, that no decree shall be reversed or substantially varied on account of any defect, any error, defect or irregularity in any proceedings not affecting the merits of the case or the jurisdiction of the court. Full stop. Next para. Taken in conjunction, the ratio laid down in Malayalam plantation supra and section and the provision of section 99 of the Code of Civil Procedure unerringly indicate towards the relevance stroke bearing of the additional evidence sought to be brought on record to the LIS. Full stop. Next para. Even if the applications for production of additional evidence which were filed by the appellant before the first appellate court were to be considered, we do not find any germane bearing of the documents sought to be brought on record to the present litigation. Full stop. Taking even if we proceeding on the premise that there is a pending adjudication before the Tika controller as regards whether the suit property is a Tika property, mere pendency of such proceeding cannot automatically confer any right or status to the property either as a Tika property or otherwise. Full stop. Next para. The courts below considered the stand taken by the appellant as to the property being a Tika tenancy independently and came to the conclusion that since it comprises of admittedly pakka structures, it does not come within the purview of a Tika tenancy with double inverted. For the next para, hence, the production of such additional evidence would not inure to any additional benefit to the appellant, even if allowed. For the next para, insofar as the notification under the Town and Country Planning Act sought to be brought on record, comma, the same does not also have any german bearing on the present adjudication, comma, since we cannot anticipate what use the property would be put to once the eviction decree is executed and the plaintiff stroke respondent takes over possession. Full stop. Hence, comma, even applying the test laid down in Malayalam Plantations Limited Supra, comma, the procedural irregularity harped upon by the appellants would not alter the outcome of the first appellate of either of the court's decree. Full stop. Next para. Hence, comma, in view of the efflux of time having been factually observed, efflux of time of the lease tenure having been factually found by both the courts below, comma, in a second appeal, comma, we are loath to interfere with such concurrent finding. Full stop. Even otherwise, comma, no substantial question of law has been raised. Hence, SAT 101 of 2026 is dismissed under Order 14 Rule 11 of the Code of Civil Procedure. Consequently, Can 1 of 2026 is also dismissed. No orders to suggested.
But only one thing, Lord, since there is a summons given by Lord the Tika controller, which is part of Lord by Order 41 Rule 27, Lord, my Lord's observation as to Lord the status, Lord, it need not be conclusive.
We make it clear that the above observations were arrived at, the above findings were arrived at only for the purpose of adjudication of the present second appeal and shall not per se have any bearing on the merits of any other pending litigation.
I'm grateful.
I have no right of audience. Maybe once you kindly notice page 17 that this suit was instituted prior to the promulgation of the 2001 Act. So that was
Take those points before the Tika controller also.
well, because since your lordship has said the suit was 2000, therefore I thought
The suit
was instituted prior to the 2001 Act. So that was an issue which was raised that the Tika, the civil court, does not have jurisdiction. And your lordship's judgment, the division bench judgment of this court is
the jurisdiction point, Mr. Mukherjee has not raised also here. Not raised also here. And we have not touched upon that also.
I know I'm hit by my Lord's judgment in Hindustan Petroleum. So, Lord, that point I have never taken.
No, that's a single bench judgment.
No, division bench judgment.
Under the jurisdiction of the civil court.
Cannot help it.
Much obliged.
Thank you. Next. 7.
7, my lord, I am for the appellant petition.
You have served the section 5. There is a direction.
Right.
For the first time. Section 5 you have to serve. Come and come.
Yes.
The appellants shall serve copies of Can 1 of 2026 and only on the respondent number 1.
Yes, my lord. Other respondent
Serve copies of Can 1 of 2026 and Can 2 of 2026 on the plaintiff stroke respondent number 1. Indicating that the matter shall be listed under the same heading in the monthly list of June 2026. Full stop. The appellant shall file an affidavit of service to that effect on the returnable date. Full stop. Service of copies on the others are pro forma or?
Yes, my lord. Other pro forma, my lord. Some of the defendant and plaintiff before your lordship 2 to 47 are the pro forma.
On the service of
plaintiff number
is on the other respondents, that is respondent numbers 2 to 47 is dispensed with for the present.
Yes. Okay. The service. The service code.
Yes.
For the appellant, the appeal is not maintainable. It's from an arbitration, so my lord, this is not maintainable. The determination is with a different honorable judge.
Oh.
Section 37 appeal.
Oh.
Refusal of admitted injunction, my lord.
Who has section 37 determination?
Honorable Justice Devanshu Ghosh's division.
But it has to be admitted under order 41 rule.
No, but still, my lord, it's there.
Let us just check the determination. That's in the original side.
No. Appellate side also.
Which page is this?
Appellate side, non-commercial also, commercial also. Everything is
It's page 27. No, This is commercial.
No,
No, yes, appeal under Arbitration Act,
my lord,
both
will
are
kindly
including applications can.
kindly bears with me, my lord. My lord, appeals under 37 against an order of grant of adjournment injunction, my lord, has to be admitted in order 41 rule 11.
Yes,
Has to be, my lord.
but this is a specific species of order 41.
My lord, with the deepest of respect, my lord, till the appeal is admitted under order 41 rule 11, my lord. My lord,
This is possibly not the procedure followed by this honorable court. Possibly.
I believe that's the
So
procedure followed
whenever-
by this court, my
No,
lord.
no. That bench, my lord, we have been all along.
That has been
Yes, yes.
taking order
everywhere
41
there,
matters.
yes, everywhere. The appeal is wrongly numbered. It should have been affirmative within bracket ARB, ARB. So even the numbering is also wrong. There's completely different set of numbering also. So this is anyways, my lord, defective.
No, but in any event, it has to be admitted on order 41 rule 11, my lord. And my lord, Justice Boschak's court probably doesn't have determination, my lord.
Seek a clarification from the Secretary of the Chief Justice, but you don't have time. You will have to come after vacation. In any event, you have to go before the. If you have to go before the other bench, that will also happen
I'll
after.
just take a moment to take instructions. Lord can do it, but
Non-commercial আছে দেখুন পরে commercial হলো পুরো arbitration.
The issue which this matter is appearing before the court below on 11.
Mr. Bordhan, we are waiting for some time. You, both of your learned juniors can also go. Just have a talk with the Secretary of the Chief Justice or the OSD or whoever and ask them for a clarification. We'll pass over the matter. Mr. Gupta, either of you can also go or your juniors can go. Right now, seek a clarification whether if it's an order 41 matter connected with appeal, arbitration appeal, whether this court has determination or the other court. Ask him. What's the difficulty in why unnecessary formality?
Every order 37 is before that. So I am presently doing 3 order 37.
Every order 41 is before us. That is the difficulty.
Yes, but all
That is the way the list has been
but
painted.
section 37
No
appeal.
exclusion is there in our list. No exclusion is there in Justice Boschak's list as well
No, but
regarding order 41.
37 appeals is specific. It's a different nomenclature also. The number is also different. It's FMAT
No,
AR.
the difficulty, Mr. Gupta,
So,
we would have
we are-
released it readily. But the difficulty is that this admission hearing
But we shall check and come.
no, just we're telling you why. Otherwise, we would have readily, we would be the happiest bench to admission of appeal under order 41 rule 11 of the Code of Civil Procedure. So Code of Civil Procedure qualifies order 41 rule.
But this is not a code of civil procedure order, my lord, because
Admission of appeal has to be under, constitute to be under order 41 rule 11, including applications connected thereto. So if you say no admission hearing is necessary at all,
no
then
admission is necessary at all.
Well, Justice Dilip says
it's a statutory
Section 37 is a statutory appeal.
Yes,
It's a different court.
probably that.
well, there's a division bench judgment. I'm not carrying it. Justice Dilip said, my lord, in 2003 or 4,
What did it say?
it says, my lord, it has to be admitted under order 41 rule 11.
Arbitration.
But we shall come back tomorrow, my lord, if you
Or we come back to
Tomorrow you won't be able to come back to it. Tomorrow we are taking up single. No, right now seek a clarification from the Chief Justice.
We'll come back.
If he says, if he washes his hands, then tell us, and that also.
And if you have the judgment, bring that judgment.
I'll try and find out.
First, find out whether we have determination or it is required to be or whatever. I mean, find out if you cannot get a clarification, we'll put it after the vacation or release it or no.
Will we just be back?
We are passing it over. এখন pass over.
Yesterday, Lordship was pleased to take up that matter. I have
What instruction did you?
I am
Forgot.
impressed Milord, what happened, Milord? This is an agreement for sale. These two matters, Milord, are identical. Two specific performance of suit where two ad interim order of injunction has been refused. Now, Milord, there was an injunction, there was a arbitration clause. That's why, Milord, the learned trial judge has prima facie raised a maintainability point of maintainability of the suit and rejected the injunction application. Now, Milord, what happened? An arbitrator was appointed.
Oh, yes, yes, yes. At your behest.
At my behest. Now, not under section 11. We initially at 21 notice
You
was
say that's unilateral, so
in any way it has no effect.
but
Now,
that is still going on.
no. Now, Milord, what happened? This is the agreement for sale, Milord, is on a 10 rupee stamp paper. Now, Milord, when the learned arbitrator, Milord, took the document in evidence, he impounded it and sent it to the collector for, Milord, valuation. And now, Milord, Milord, the collector took a very long time, Milord, several months, Milord.
Then you have section 9.
Exactly. Now, Milord, when it came back to the arbitrator has, Milord, given an order. Now, at this moment, my mandate is terminated. 1.5 years over from the completion of date.
So you said you don't have a remedy in arbitration right now, but still section 9 is your remedy.
Section 9 is
Not a
my
suit, not a
remedy. Yes, that is there.
Either you can ask for his extension of his tenure or appoint a new. Section 29 is there. 29 or
Extension,
29.
Milord, perhaps extension in this case, Milord, is because the route
the tenure-
itself is bad, because unilateral appointment of arbitrator is
Section
section
9 and
11.
6 section, yes. Section.
Milord, only one thing, Milord. After this, Milord, the respondents are aware of this. I will file, Milord. I have, Milord, impressed upon the learned advocate in the trial court. Milord, he will definitely file, Milord, within the on the reopening.
Then you have to withdraw.
Definitely on the reopening date. Till
You have to withdraw it right now.
Definitely, I will do. But
then do that. You say
yes,
withdraw.
yes. But till 1 week after vacation, Milord, kindly protects me, Milord. They are aware of this order. They are following the matter, Milord. Property will
Tomorrow
go.
file a section 9 and you do a copy paste and file it tomorrow.
Pleadings are ready almost.
Obviously. So file these pleadings before the section 9 court and get an order.
And otherwise, Milord, the property valued at, Milord, more than 10 crores, Milord, will be.
No, that we understand, but then it has to be a commercial.
Rajarhat, commercial.
It's a commercial transaction.
Yes, agreement for sale. Milord, valuation is, Milord, much higher. Big plot of land.
The plot of land must be for a commercial purpose.
Commercial purpose, Milord, that is, Milord.
We don't want to advise you either withdraw or with dismiss.
Yes, withdraw with liberty to file, Milord, approach the appropriate forum.
Learned counsel for the appellants submits on instruction that the appellants seek to withdraw the appeal with liberty to file before the appropriate forum. We'll specify the forum.
With the appropriate forum, Milord, anyway.
Under the arbitration law. Under the Arbitration Act. That is what we say.
Yes, under the Arbitration Act. Yes.
Appropriate forum under the Arbitration and Conciliation Act 1996. Push up. Accordingly, FMAT 159 of 2026 and FMAT 160 of 2026, along with the connected applications, bearing can 1 of 2026 in both the appeals, are dismissed as withdrawn with liberty to the appellants to prefer appropriate challenge under the Arbitration and Conciliation Act 1996 on the self-same cause of action. Liberty is given to the learned advocate on record for the appellants to take back the certified copies upon furnishing photocopies thereof for the records.
Subject to correction, not challenge for interim order after appropriate, because injunction was refused.
Appropriate challenge na kore, appropriate initiate an appropriate proceeding. With liberty to initiate an appropriate proceeding before the appropriate forum.
Milord, asking, Milord, too much, Milord. If it is filed, Milord, immediately, Milord, the learned trial judge will.
No, there is no question of time bar. Section 9.
No.
Injunction.
Yes.
For the first
ad interim.
No. Can we do that? We used to do that when we were more lenient. Nowadays, judges are bad, so they don't.
Very valuable property, Milord. That's the whole difficulty, Milord.
This is my appeal. Well, the suit for partition, declaration, and permanent injunction. At the ad interim state, the learned judge passed an order of status quo in respect of the nature and character and possession of these But it is well.
There are certain defects here. Preamble, presiding judge's name is not there. One. Secondly, something is not there. Valuation statement is not here. It arises from what? You have annexed the plaint anywhere.
Yes,
it's from a suit.
Suit.
The valuation statement had to be given. Very well. We'll ask you to insert the valuation statement.
Yes.
Leave is granted to the learned advocate on record for the appellant to rectify the preamble of the memorandum of appeal by incorporating the name of the learned presiding judge of the trial court. For sub next para, insofar as the second defect pointed out by the additional stamp reporter, leave is granted to the learned advocate on record for the appellants also to insert a valuation statement in the memorandum of appeal. For sub, since we find from the plaint, from the copy of the plaint which has been annexed to Can 1 of 2026, that the valuation of the suit from which the appeal arises is rupees 10 lakh 180, this court has pecuniary jurisdiction, and as such, the appeal is taken up for hearing under Order 41 Rule 11 of the Code of Civil. Yes. Partition suit status granted, rightly?
Yes.
Why shouldn't it
No,
be granted?
well, only thing in this case, the oral partition also a partition. On the basis of that, I taken permission from the local panchayat for making construction. Whether construction was started.
Oral permission you have to establish by evidence in the suit.
Certainly.
It's a matter of trial.
Only pair is that to rectify, modify the said order of status quo to that extent to complete my construction, because the before 1 month when the construction is commenced, they did not made any objection. But after roof casting, they filed this suit and obtained this order.
This is at the ad interim stage.
This is the ad interim stage.
Your version is not on record. Contest the injunction application by filing a written objection and point
yes.
out these
But
things.
in the meantime, if your
This will
lordship that
entertain,
has not been
this will permit you to, this will entitle you to file an Order 39 Rule 4 on the ground of undue hardship or written objection and decision of
during that time, those materials are gathering in the on spot, that will be destroyed.
At ad interim stage, it has to be on the basis of the plaint. The present appeal has been preferred against an order of ad interim status quo in respect of nature, character, and possession of the suit property passed in connection with the partition suit. Whose next para, learned counsel for the appellant, defendant stroke appellant argues that the defendant stroke appellant has already started construction, and for such purpose has accumulated construction materials, which, in the event of subsistence of the injunction order, would get deteriorated. For sub next para, that apart, it is contended that there was an oral arrangement between the parties, by virtue of which there was an amicable partition of the suit property. For sub next para, be that as it may, such questions as sought to be raised by the defendant appellant were not before the learned trial judge, since the injunction application, since the injunction order, at the ad interim stage, has to be granted on the premise of the pleadings and materials produced in connection with the plaint and the temporary injunction application. For the next para, however, in any event, it will be open to the defendant stroke appellant to raise all such questions, either by way of an application under Order 39 Rule 4 of the Code of Civil Procedure, or by filing the written objection.
Already been filed. Written objection already been filed.
Or by filing a written objection to the injunction application, which, we are apprised, has already been filed. Full stop next para. Accordingly, there is no scope of interference with the impugned order at this stage. Full stop. Hence, FMAT 171 of 2026 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can 1 of 2026 is also dismissed consequentially. It is no orders to cost. It is made clear that we have not, that the above observations or the observations made in the impugned order are tentative in nature and shall not prejudice the learned trial judge unnecessarily while adjudicating the temporary injunction application finally, and or at any other stage of the proceeding. আচ্ছা, one other আরেকটা প্রথমেই একটা অ্যাড করে দিও, liberty is granted to the learned advocate and record for the appellant to properly classify the appellants in the cause title of the memorandum of appeal. You have written appellants plaintiffs, it will be defendants appellants.
But only one thing, the time may be fixed for the disposal of these
Not in
applications.
agreement. Please correct the cause title also. You have said plaintiff appellant.
But the advocate and record is common code. My lord,
Yes.
This matter, I have not lodged any caveat, my lord, but I contested in the court with
The misappeal.
misappeal.
What do you say?
I
You
can
give a copy
always, yes, I have a copy, I will give it. My only
What have you challenged here?
I obtained the injunction, continued for some time, and moment the injunction vacated, they started demolishing my building. Injunction order passed in 14th. They started demolition. I filed in Monday, means day before yesterday. Day before yesterday, and today we have come. Now, Lordship, the case here is.
No, the injunction has been vacated or what?
Yes, vacated. My injunction application is rejected on a very strange ground, my lord. But be that it may be, I was protected, and now today I am unprotected, and the promoter is making construction there.
Now, on what ground was it dismissed?
Dismissed, His Lordship. I am suffered degree, eviction degree. Eviction degree confirmed up to High Court. Execution going on. In the execution, I found fraud. I reported that fraud. Meantime, there was a change of hand, and Lordship, promoter came in. Now the promoter started throwing me out of possession. Moment
You have no legal status.
Yes, yes.
The property. How could you get an injunction?
I am in possession because
Mere possession would not entitle you to injunction. You have to
Yes.
have a legal possession,
Lordship.
because if you are a defendant, you cannot be thrown out without due process of.
I was a defendant.
This is
In
not
a eviction, I am a defendant.
No, here you have filed the suit. You are
Yes.
the plaintiff.
Yes.
So as a defendant, you would be entitled to say that I cannot be evicted without due process of law. As a plaintiff, you cannot assert right, get an injunction against the true owner. That is very well settled.
No, but I am saying this. I am a defendant in a suit property.
That you have already lost. You are no longer a defendant. You are a judgment debtor.
But yes, I am a judgment debtor.
So you have no legal status.
No,
How can you get an injunction?
No, Lordship. I am in possession. Without
Possession simplicity is
so
does
without
not count.
yes. So
Not for injunction.
then Lordship, without execution, possession can go from my hand, from the judgment debtor's hand. Lordship, kindly see. Possession can go out of the judgment debtor's hand by two ways. Either I surrender or belief takes. There cannot be any third way.
No, you have no legal status. You cannot get. You are not entitled to get
Lordship,
injunction. Is the true.
yes, Lordship, kindly see. If I say that a judgment debtor has no legal status, that is one part. To enforce any right, but to protect the existing possession.
That is also right.
No, Lordship, that right is embodied.
Possession is not lawful possession, Mr.
Lordship,
Not a law.
then after it,
has reached its finality, appeal and all are exhausted.
Yes.
no, Lordship, kindly see. If I go by that, if I just think in this case, in this scenario, then after degree, execution filed, someone is in possession, then without belief or without due process, I can throw him out. He cannot protect himself. Yes, Lordship, he can. Because
you also have order 2101.
Yes.
So you did not take recourse to that. As
Yes.
is not maintainable also on that.
Yes.
But
That's the point. I can take that recourse in the execution court. That is the finding of this court, which is correct. But when I am thrown by a third party.
No, but
Lordship.
No, but sorry, you cannot do that also because you are not a third party. You cannot take recourse to 97 to 101.
Yes.
You are the judgment debtor.
Yes.
So you cannot get benefit of order 22 97. You don't have a right there also.
Order.
It's fraud.
Yes, fraud is
lost in all the forums and now fraud.
No, now fraud, and court is hearing me on that. No, Lordship, I'm not coming on that. Kindly see, visualize this. Order 21, Rule 97, police protection is something different. This court says, I can go to my injunction in the execution proceedings, and I can protect my right. Or else, Lordship, if the third party is evicting me, then where should I go? Should I not institute a
Third
suit?
party is claiming through the degree holder.
No. Third party is not claiming to the degree holder. Then he would have devolution of interest, Order 22 Rule 9. Then I have got nothing. If a devolution of interest, then Lordship, I am protected by the executing court. But when it is a third party in agreement with the degree holder, throws me out. Otherwise, kindly visualize this, Lordship.
What? Ad interim was refused.
No, ad interim given.
They
Continued.
The
They
defendant-
applied.
The defendant appeared.
Appeared, contested, and they gave a document before this court to believe that they paid 40 lakh in cash to someone who was staying there. It's unheard in the income tax law because below 20, above 20,000 cash transaction is not. And they have that guards to produce the chalan gulo de. They have guards to produce those chalan on affidavit before the court and said, yes, he has been thrown out.
What is their objection?
Lordship. If your Lordship kindly see one objection. First objection is at Lordship Volume 2. Lordship, I have some defects also in the matter. It shows in the
What sort of?
117. Some defect was also there. Lordship, I undertake to do. But my
Preamble is bereft of valuation statement. The valuation is above value. We have determined.
Yes.
So you insert the valuation statement, you're
Yes,
granting
that-
the
if your Lordship kindly see one document before I take their objection, one objection document. If your Lordship kindly turn to, they have said that no, I am not evicting him. What is their language? I am not evicting him. His all employees are taking 10 lakh, 15 lakh from us
You are
and
P-
leaving.
You are P7.
Yes, yes.
You are P7.
Yes, yes. Lordship, they are saying that my employees have taken 10 lakh, 40 lakh, all in cash from them, and they have given receipts for that. And then they said they have left.
Let us see their case, Mr.
Lordship, we will see their case. Lordship, if your Lordship kindly see,
Written
other
objection at page 117, yes.
117.
Lordship,
What there?
117. Now, Lordship, kindly see 117. Now, kindly come to page
But
121.
do they stake their claim to title in that objection? We want to see their
Their stand. How they are evicting me.
Yes. No, not evicting. Before that, what is their locus standi in respect of the suit? In their written objection, what have they claimed? What is their right to the suit property?
They purchased. Lordship,
From the degree holder.
I must say this. Lordship, the respondent number 1 to 4 with devolution of interest.
So when you just come back and
Yes,
continue. Yes. They were substituted in this case, execution case.
They were, yes. That substitution was also done after 10 years of their purchase. That order was challenged before Honorable.
So it's a bad case. Not only a bad case. You don't have a case at all. So what product you have alleged? Let us see your suit.
No. In this suit, I have not challenged any fraud. That is what I am trying to explain, Lordship. The suit is not pertaining to any fraud.
Rightly dismissed.
No, I'm coming.
No, please complete quickly. Yes. Complete quickly. You have got no point.
No, Lordship, what I'm saying is, just visualize this. I suffered a degree. Now I am facing execution. In an execution, the decree holder, substituted degree holder, comes and he makes an arrangement with a third party. That third party throws me out. And then belief did not give him possession. I did not surrender possession, but he recovered the possession. Is this a I put this question to myself. If this is permissible, order is perfectly valid. If this is not possible.
Who is a third party? Among the defendants?
Yes, that was I was saying, Lordship.
Who is a third party? Page
Yes.
71 of the array of parties.
Yes. Kindly come to 5.
5 is a third party.
Third is a third party.
1 to 4 are the
substituted degree holder. Yes. Lordship, they have substituted themselves. Late came in. I am not into that. Now, Lordship, kindly see for a moment. Lordship, kindly see the agreement. If your Lordship.
Ask for the injunction against all the defendants. You artificially added a third party and you have asked for injunction against all. So this is bad for misjoinder of causes of action also.
Maybe. Lordship, but
then also you don't have a prima facie case.
No, Lordship, kindly come to page 165 once now. Now kindly come to, then everyone will make a third party arrangement and with a private mechanism will throw him out.
Otherwise, everyone will add a third party and a judgment debtor will file a suit. The next day, they suffer an eviction decree and get an injunction from a court.
No, Lordship.
Absurd proposal.
Lordship.
Absurd.
Lordship, kindly come to 165. Kindly see my 3 documents and the Lordship, I will not.
Your documents?
No, their document. 165. Lordship is.
They've already been substituted in the execution case.
No, Lordship. He is not substituted. How 5 has come into play?
1 to 4 agreement with 5.
Yes. 165. Lordship
5 is acting as agent of this 1 to 4.
Lordship, kindly see, not agent, principal to principal. 165. Lordship has seen that?
Yes, we are there.
Now, Lordship, kindly turn to page 102 of that agreement.
Page
202. 197 no much, but 202 very clear. Lordship, kindly see how they are doing the private execution. That has to be seen, Lordship.
Yes.
That the developer, together with the help of the landlord, independent, shall arrange to shift the occupier being P7. That means they think that I am in possession at the time of, and also jointly settle with the said occupier to withdraw all suits, proceedings initiated or filed by the said occupier against the present owner as well as with the previous owner, further declaring that there shall remain no dispute and no claim between the owner and the said P7 and against such other in presence or in future, that on failure to get the property fully vacated, the P7 except Bengal furniture such as within a period this from date of execution of this agreement and on failure to obtain sanction on such and such. So, Lordship, he introduced a man for execution. Now, Lordship, kindly see how he executes. Now, Lordship, kindly come to page 121. That is their own averment. I am not going my thing. Now, what he says, and then I will show their document. So, this is their agreement. They introduce a man to execute what court could not do, what belief could not do. Lordship, kindly see. Since P7, in spite of the degree suffered in both, Lordship got
121?
Yes, Lord.
Yes.
Now, Lordship, this is their objection. That since the P7, in spite of degree being suffered, such and such was going on, during the course of execution, talk of settlement went on, respondent number 1 stepped in to facilitate the settlement. it was stated by the plaintiff that to arrange their business and to purpose of shifting some fund is required. Beside that, the plaintiff have permitted some of his employee to take shelter at some portion of premises such and such, and they have got their due salary benefit and also rehabilitate the other places, and accordingly a fund of 55 lakh was paid to P7 by this through bank transfer. Beside that, the employees of the police was also provide cost of rehabilitation such and such residing this. Kidwai surrender their respective possession from the premises such and such on getting the fund shifted such and such. That on account of the cost of rehabilitation, defendant number 5, that is independently, incurred an amount of 77 such and such lakh of rupees. Answering respondent shall prove the same at the time. The say copy of the surrender letter and the document and annex. Now, Lordship, kindly see, I could not annex because otherwise, in objection, I would have got, because type copy is very illegible. Original I am carrying, Lordship, the document which they kindly see this. Lordship, kindly see this document once, which he referred is a complete private execution of a decree. Now he says, that is his averment, and now he says he is a third party. I don't want to use any term. He takes over the thing, litigation. And he purchased the litigation, he settled, and how he throws. Then he says,
Anil Gomes is your man.
They is my man. He says that Anil Gomes has taken money. How much money? In cash, in document. Lordship, now Lordship will find in which date this stamp papers was also purchased. Lordship can go into this. This is their stand. The third party has come, which court could not do within time. I may be a bogus litigant, but was in possession. My right in their possession was recognized in their arrangement document. I was not there. I did not say put my name there. They made an arrangement to throw me out of the premises, favoring when I approached the court. Add interim order to the court. Add interim order, page number bolo. Lordship, now Lordship kindly come to page 16, 116. Lordship, they have said that up to 40 lakh also.
16 of
volume 1, Lordship. First, I have shown those document, Lordship, that how they have paid according to their statement. Annexures to their support of their statement, Lordship. Because I have annexed the written objection without this. Now, Lordship, 116. The interim order, ad interim order which I obtained. Having such and such, document annexed thereto, admittedly the plaintiff has suffered an eviction degree, such and such, disposed of such and such, and still pending, and it is alleged by the plaintiff that the defendant number such have entered into register developed such and such. In the recital of deed, agreed between the defendant together with such and such, arrange shifting such and such, accordingly drifting and now trying to evict this, in his prayer such and such, on perusal of the development agreement with the petition, it appears that the possession in this way is admitted and such and such. The title executions is still pending. There is an ad interim order of temporary injunction, such and such, such and such. So, Lordship, when I said to the court, now see, the third party, by way of an agreement, executing a decree. This should have been done by police self, order 21, rule 97. That's what Lordship said. Or order 2101. Then Lordship, what belief could have done, what police could have done, this respondent number 5 is doing. So, Lordship, I jumped into that court and said, kindly see, protect me, because I cannot get the relief against him in my executing court. So, Lordship, then the court granted me. Now, Lordship, kindly come to the impugned order. Now, why I am been rejected?
162.
162. Now, Lordship, kindly come to my rejection order.
Yes, which page?
162.
The present impugned order.
Present impugned order.
You can place relevant portions. You have read it.
Yes.
But you can.
So, Lordship, if your Lordship
can stand that you have already voluntarily vacated. That was another stand which you were relying on this, on the basis.
Yes, that is, they said, see, they executed, they throw me out and say voluntarily vacated. Lordship, if this be allowed, Lordship, if we think about law rule, then Lordship, everyone would have said that after getting degree, everyone can execute his degree in his own way. So, Lordship, a court of law, from the starting point is the eviction notice, end point is the belief report. Unless the belief report files, the case is there. So, Lordship, my possession is there. I have to be protected. Now, Lordship, kindly see how the logic of the impugned order comes. Now, Lordship, kindly see.
You have seen it, considering the interfaction circumstance.
Lordship, considering the interfaction circumstance, the document prima facie is still suffering a degree, trial court set aside through such and such, all matters such and such by executing court. So, again, having regard to document annexed with the plaintiff, injunction at this stage is of the opinion plaintiff failed to establish prima facie case. So, Lordship, I lost the matter on found a prima facie case. But, Lordship, what I had to show that yes, I am in possession. Yes, execution case is going on. Yes, a third party has come into for executing. So, Lordship, these three are there from the agreement because agreement he has considered.
The present appeal has been preferred against an order whereby the temporary injunction application filed by the plaintiff stroke appellants has been dismissed. Next para. The learned counsel appearing for the plaintiff stroke appellants argues that the decree holders stroke defendant numbers 1 to 4 in the present suit, comma, in collusion with a third party, that is the defendant number 5 in the suit, comma, have been attempting to throw out the plaintiffs unlawfully, plaintiff stroke appellants unlawfully from the suit property. It is contended that although the plaintiffs have suffered a decree, comma, eviction can only be obtained in due course of law through the process of court and not unlawfully by arrangement with a complete stranger to the suit. Next para, in the present case, comma, it is pointed out, comma, the defendants relied on a purported surrender letter.
Not a Lordship series. They have shown that
purported surrender letters indicating that the appellants have allegedly surrendered the suit property.
My employees.
Appellants' employees have surrendered the suit property. No, you are in your independent capacity of filer.
No. I filed in independent capacity, but they are my employees, servant.
Anil Gomes is not one of you.
No, not one of them.
Not one of them.
No. My servants, my drivers, my workers.
All right. Employees. Next para, learned counsel that submits further that the learned trial judge failed to take into consideration the fraud practiced upon the process of court by the defendants in seeking to oust the plaintiffs by such oblique manner. Next para, it is argued that since the plaintiff's possession in respect of the suit property has been established and as it is a third party within bracket defendant stroke respondent number 5 bracket close, which is attempting to take over the decree and oust the plaintiffs, comma, the learned trial judge ought to have granted injunction protecting such possession. Next para, on a careful perusal of the materials before us, comma, we find that admittedly the plaintiff stroke appellants have suffered an eviction decree by the trial court, comma, which was affirmed up to the first appellate court. Next para, thus, comma, the status of the plaintiffs are judgment debtors vis-a-vis defendant stroke respondent numbers 1 to 4 herein. Next para, the respondents rely on an agreement entered into for development of the property with the respondent number 5, the defendant stroke respondent number 5. Next para, in terms of clause Roman 15 of the same, comma, the developer within bracket respondent of 5 bracket closed, together with the help of the landlords bracketed defendant stroke respondent numbers 1 to 4 bracket close, shall arrange the shifting of the occupier being double inverted peace haven HAVEN within bracket owned by the present appellants bracket closed, and also jointly settle with the said occupier to withdraw all the suits, comma, proceedings initiated and stroke or filed by the said occupier against the present owners, as well as with the previous owners, further declaring that there shall remain no dispute and stroke or claim in between the owners and the said P7 against each other in the present or in future. For sub next para, thus, comma, from the said agreement, comma, it is palpable that in view of the long pendency of the execution case and the preceding eviction suit, comma, the defendants numbers 1 to 4 stroke decree holders entered into an arrangement with the developer not to forcibly oust the judgmentator stroke appellants, but to enter into an arrangement with them. For sub next para, in any event, comma, the respondent number 5 is not acting in independent capacity in doing so, but, comma, by dint of the development agreement, comma, in the capacity of an agent of the decree holders. For sub next para, it is well settled that a person failing to establish lawful possession of a property cannot get an eviction against the true owners. Full stop. The said principle holds good all the same in respect of a judgment debtor in an eviction suit. Full stop. After suffering an eviction decree, comma, the judgment debtors have no legal status in respect of the subject decretal property. Full stop. Next para. Thus, comma, a judgment debtor is not entitled to file a suit and get an injunction protecting his possession against the decree holders. First up, if such a proposition were to be encouraged, comma, there in every case where an eviction decree is suffered, comma, the judgment debtor would merely go before the court and file an independent suit, comma, obtaining an injunction therein from being ousted from the suit property. Full stop. Next para. Insofar as the purported surrender letters are concerned, comma, per se, comma, the surrender letters merely show that voluntary possession has been handed over by the plaintiffs stroke appellants. Full stop. Next para. The veracity of those have been squarely challenged by the plaintiffs before us. Full stop. However, comma, no such amendment in the plaint has yet been incorporated. Full stop. Be that as it may, comma, even without going into the question of veracity or validity of such surrender letters, comma, fact remains that in the garb of injunction against the third party, comma, in the suit, comma, the plaintiff stroke appellants within bracket judgment debtors bracket closed have in effect sought injunction against all the defendants, comma, including defendant numbers 1 to 4 stroke decree holders. Full stop. Defendant number 5 has been added as a party, but at the end, comma, is only an agent of the decree holders. Full stop. Thus, comma, what the plaintiffs stroke appellants seek to achieve is to obtain an injunction against the decree holders, comma, despite having suffered an eviction decree against in respect of them before two forums. Full stop. Next para. Thus, comma, in the absence of any legal status, comma, the plaintiff stroke appellants were not entitled to get an injunction at all. Full stop. Hence, comma, we find no illegality in the impugned order whereby the temporary injunction application of the defendants plaintiff stroke appellants has been dismissed. Full stop. Accordingly, FMAT 172 of 2026 is dismissed under order 41 rule 11 of the Code of Civil Procedure, can 1 of 2026 is also dismissed consequentially. No orders to cause urgent settlement. Mr. Banerjee, you can take back this or you can hand over a copy of this because you've argued on this, you have recorded. Only one of the surrender letters copy, please hand it. Thank you. Next.
More bless.
The password matter.
Password.
No, they had been.
One. Yes.
No, they had been to the department. My lord, they say, my lord, it is within the not within the administrative jurisdiction, my lord. So, and I'll
The intention was to take clarification from the chief, basically.
And I tell you why two courts have jurisdiction. My lord, kindly has a look to the appellate side rules, chapter 5, rule 17. I'm sorry. Why, my lord? Two courts will have determination, my lord.
Rule 5.
Rule 5.
Rule 517.
Chapter 5, rule 17.
Chapter 5, rule
17.
70.
Why, my lord, two courts? This is, my lord, would see A. In the case of an appeal from original decree, an appeal under Workmen Compensation Act, an appeal from an order under 226, an appeal under Railways Act, an appeal under Motor Vehicles, an appeal preferred under 37 1B of the Arbitration and Conciliation Act, thereby setting aside an arbitral award under 34, a first appeal against a deemed decree, provided in the statute, if the said deemed decree is not passed in execution proceedings, admit it and cause it to be registered and notice to issue to the respondent. Then, in the case of an appeal from an appellate decree or an appeal from an order other than an appeal under the Workmen's Compensation Act, appeal from an order under 226, appeal under Indian Railways Act, appeal under Motor Vehicles, and first appeal against deemed decrees passed in execution.
This is under 37.
Yes, ma'am. Then let's kindly cease all other appeals under 37 of the Arbitration Conciliation Act except the appeals preferred under 37 1B, thereby setting aside an arbitral award under 34, cause it to be registered and posted to a bench for hearing under order 41. So, my lord, section 9. So, my lord, order 41 in my most submission, my lord, it has to be admitted on order 41.
Possibly, if your lordship kindly see section 37 1B, because this says except appeals preferred under 37 1B. Ours is 37 1B.
No, that has got an amendment.
Section 9.
Place that, a coordinate bench has held that.
No. There are two paradigms. A says thereby setting aside an arbitral award under section 34 that goes directly.
That's
And the mirror image of that is in B, except appeals preferred under 37 1B, that's not unqualified, thereby setting aside an arbitral award under section 34. So only section 37 is against section 34.
Yes, but
those are directly.
Kindly see section 37 1B.
No, it's specified 37 1B setting aside and under section 34.
But that is not there in 1B.
Kindly
see 37 1B.
Arbitration Act has undergone an amendment, but kindly sees the coordinate bench judgment.
But there's a judgment also. I need to come back on this because then lots of matters we have done would be.
You have done without order 41 hearing?
Yes. All matters. This is for the first time I am countering this.
Therefore,
several matters we have done.
Therefore, two courts will have jurisdiction. One is the statutory appeal in the sense, first appeal. So only notices to be issued, not to be posted.
37 1B cannot be correct because it's specified setting aside an arbitral.
Yes, yes, but kindly see 37 1B. The land
has been amended.
Look at the rules. Appellate said rules, Mr. Gupta. You have to look at the rules as a whole. Obviously, B is a misnomer because it's mentioned in both A and B of Rule 17 that thereby setting aside an arbitral award under Section 34 of the said Act. It has to be C.
Has to be read as C.
Has to be read as C. Because it's specified, it's qualified, not merely. It said it would be an impossibility otherwise. We have to harmoniously construe it. Setting aside an arbitral award is in words, categorically. So if it's a Section 37 is Section 34, which is of a final nature, that's of a nature of a first appeal it's treated here.
And kindly permits us to come back once.
Okay.
because I really need to, my lord,
Lord, the
kindly
issue is-
come, kindly, may I come back tomorrow, my lord, because there's some urgency.
Tomorrow we don't sit.
There's some urgency of this.
Don't sit in division bench. That's a difficulty. Don't sit.
My lord, in fact, my lord, I have placed a coordinate bench judgment of this court, my lord. Kindly seize it. The court, this is
How would be affected either way? But rather, you have more of a chance of the appeal being dismissed at the order 40,
yes.
order 41 rule 11 state. Otherwise, it would not be there. Directly, the appeal would have to be.
My
the
submission,
application then would be taken.
my submission, possibly admission, everything has to be done before the court having determination under Arbitration Act.
Now,
But
my lord,
the judgment which my learned senior friend is placing speaks to the contrary.
But only this court has order 41 hearing determination.
Yes, but the judgment which my learned senior, I have also taken that out.
Achha.
That somehow speaks to the contrary, and the matter was released for being admitted, and then
Let us see.
yes, for being admitted, right through. Rightly so.
At the same range.
And my lord,
This was the section that the arbitration court
yes, my lord,
which passed the judgment.
kindly seize, my lord, the observations.
Yes, 4 and 5 clear.
yes.
Accordingly, we do not have determination to hear admission of appeals and order 41.
I've been told there has been some change in the rules recently, but kindly permits us to come back tomorrow once, my lord.
Tomorrow we are not sitting in division bench. What is the urgency? Section 9 has been rejected. What is the nature of injunction?
My lord, section 9 was at their instance, my lord. It has been allowed. Ex
Thereby,
parte. My lord, a tender which was floated in 2024. My learned friend's client was the unsuccessful tenderer, my lord. In 2026, they file a section 9.
but Mr. Gupta, this judgment is very clear. The arbitration court released it to be placed before the order 41 bench.
This I just now came across, my lord, I understand, but both of us called out just now. So many different lordship
This amendment was also suggested in paragraph.
yes. Now,
No.
So many different lordships.
They have an urgency, otherwise we would not do it. At the outset, we are deciding this first. At the outset, comma, learned counsel for the respondent raises an objection as to this court having determination to take up the matter, comma, since it is an appeal under section 37 of the Arbitration and Conciliation Act 1996 against an order passed under section 9 of the said act. Whose next para, learned counsel point for the respondent points out that a different coordinate bench has blanket determination in respect of appeals under the 1996 Act, comma, including applications connected thereto. Whose next para, learned counsel for the appellants, comma, on the other hand, comma, refers to Rule 17 of the appellate side rules of
Chapter
this
5.
code. Rule 17 of chapter 5, Roman 5 of the appellate side rules of this code. In clause small a thereof, comma, it has been contemplated that applications preferred against orders setting aside arbitral awards under section 34 of the said act would be treated as a first appeal against a deemed decree, whereas under clause small b, comma, all appeals under section 37 of the 1996 Act, comma, except appeals setting aside an arbitral award under section 34 would have to be posted for hearing under order 41 rule 11 of the Code of Civil Procedure. A conundrum arises since, while so stipulating, comma, both the said clauses refer to section 37 within bracket 1 within bracket small b of the 1996 Act instead of section 37 within bracket 1 within bracket clause small c of the 1996 Act, comma, the latter pertaining to setting aside or refusing to set aside an arbitral award under section 34, whereas clause b refers to section 9 orders. Full stop. Next para, learned counsel, comma, however, comma, cites a judgment of a coordinate bench of this court where such conundrum was clarified. Full stop. In the said judgment, comma, the coordinate bench observed that clause small a of rule 17 of the appellate rules enumerates the categories to classes of appeals which do not require admission under order 41 rule 11 of the Code of Civil Procedure, whereas clause small b indicates appeals which require admission. In the reading of the coordinate bench, comma, an appeal under the Arbitration and Conciliation Act 1996 accepting an appeal under section 37 within bracket 1 within bracket small b square bracket, which is now section 37 within bracket 1 within bracket small c square bracket closed, from an order setting aside an arbitral award, requires admission. So accordingly, the coordinate bench release the matter to be placed before the bench having determination to hear matter appeals under order 41 rule 11 of the Code of Civil Procedure. Next para, simultaneously, the coordinate bench observed that the Honorable the Chief Justice may consider amendment of Rule 17 of Chapter 5 of the Appellate Side Rules, to the effect that Section 37 within bracket 1 within bracket small b needs to be replaced by Section 37 within bracket 1 within bracket small c of the 1996 Act, and as to why, where a statute provides for an appeal as a matter of right, such appeal should require to be admitted under Order 41 Rule 11 of the Code of Civil Procedure. Next para, even independently of the coordinate bench judgment, we find that determinations have been given to separate benches for taking up matters for appeals pertaining to the 1996 Act and for taking up Order 41 Rule 11 hearings. Next para, a complete and harmonious reading of Rule 17 of Chapter 5 of the Appellate Side Rules clearly indicates that it has been enumerated in words that only appeals under Section 37 of the 1996 Act, which are preferred against orders setting aside an arbitral award under Section 34 of the said Act, are to be treated as first appeals, not requiring any admission under Order 41 Rule 11 of the Code, whereas it is just the reverse in case of other appeals under Section 37 within bracket 1 under Section 37 of the 1996 Act. Next para, thus, clause small b of Section Rule 17 clearly applies in the present case. We, in our opinion, ought to go by the words of the rules instead of the wrong enumeration of section, which was rightly recognized by the coordinate bench in the matter of Murshidabad Zilla Parishad Supra, cited before versus such and such, cited before us. Next para, accordingly, since this bench has determination to hear appeals under Order 41 Rule 11 of the Code for the purpose of admission, in consonance with the ratio of Murshidabad Zilla Parishad Supra, we hold that this court has determination to hear the appeal under Order 41 Rule 11 of the Code and accordingly proceed to hear the same under the said provision. Yes, what is that?
Now, Mulot, there's a condemnation of delay application of 22 days, Mulot, in the first, I wouldn't say first appeal, Mulot, the prior appeal. 22 days delay.
What is the reason?
Mulot, initially, Mulot, there was an interim order of injunction. Now, we preferred a vacating application in the hope that the vacating application will be heard. Now, it went on being adjourned regularly.
But I like to use an affidavit, Mulot, because they have the next item is an appeal from the extension order also.
Yes, Mulot. Now, I'll
show and
Section 22 days delay.
But it's really not.
You make your arguments because the facts you cannot know. Whatever they have said, that I mean, on facts why they committed the delay, these are admitted, these are from records. So that there was an application for. So what is your argument on that?
They contested in the court below. So it's now that they have come up in the appeal. So they were contesting the vacating.
So without an opposition, you make your arguments. That is
yes, but that is my argument. That they were contesting the vacating. It's really they're wanting because they couldn't get that expeditiously disposed of, that they're coming up with appeal. That perhaps cannot be a ground for condonation of delay in preferring an appeal.
No, initially under Section 9 an order was passed in your favor, ad interim order.
Yes, that has been extended.
Now,
also. So, and they have preferred a
vacation is in respect of the parent order.
And the next appeal is in respect of the extended order.
That does not have a condonation application.
No, but yes, but they have filed a vacating there and were contesting there. So now they are coming up. This possibly that this cannot be. Those are my
what do you say to that?
I have an answer to this.
Because these are not alternative remedies that one you are pursuing. You
my
take
lord,
a chance there,
no, my
you
lord, it's not
appear there.
it's not a taking chance, my lord. I prefer an order 39 rule 4. My lord, the ambit and scope of order 39 rule 4 is different, my lord. So I am well entitled to, my lord, to maintain this appeal. And my lord, I'll tell you the reason why. In fact, my lord,
But then you cannot cite that as a reason for you not filing the appeal in time.
no, my lord,
Because these are different scopes.
my vacating application was not being heard on a regular basis on the ground that the learned counsel is busy. My lord, kindly says, takes the
Mr. Bordon, the moment you cite Order 39 Rule 4 pendency as a reason for the delay, you give a go-by to your other contention that is a different relief, appeal is a different relief. You could simultaneously have preferred both.
Well, there was a delay of 22 days on our part in filing the appeal. There's no qualms on the scope. That was there. But the reason is, Millard, that we were expecting that our vacating application would be heard. Millard, may I put it this way? Merely because the court is unable to, Millard, take up my application, it goes on mechanically, Millard, extend the interim order. Millard, and I'll place all the orders have been placed. Millard would kindly take up.
No, we are proceeding on the basis that would not be taken up.
Millard, so this on regular dates, Millard, 11/3, counsel absent, and then Millard, it goes on to on a different level altogether. On a particular day, Millard, the extension order is not even filed.
So we are condoning the delay. We are giving the reasons.
What I was humbly beseeching, if a time period be framed within which we can just 2 weeks after the vacation, within which we shall have the 9 finally heard and disposed of.
Not so easy, Mr. Gupta, now because the fallout is now being suffered by the courts because there was huge pendency during that period. Direct passing a direction is very easy sitting here. If we could do that, we would do that ready.
As in, yes, yes.
Not
Yes.
that is having its fallout.
Because this is really
the pending matters are now being their body.
But the ground which they are taking for condonation of delay, that could not be heard. Possibly that is not really,
We'll deal with it.
because they should have then preferred a expeditious disposal, my lord, and with the direction there, my lord. But because it is delayed.
Take note of it. Which appeal is this?
This is 130 of 2026.
FMAT 130 of 2026 has been preferred against a parent order whereby ad interim injunction was granted under Section 9 of the Arbitration and Conciliation Act 1996. The delay in filing the appeal is of about 22 days. Sublearned counsel appearing for the appellants argues that initially, under the impression that the appellants would get immediate remedy, an application under Order 39 Rule, application in the nature of one under Order 39 Rule 4, for vacating the ad interim order was filed before the Section 9 court. However, by relying on the said application was kept pending for long and has not yet been decided, due to no fault of the appellants. Learned counsel seeks to rely on the order sheets of the proceeding in support of such contention. Next para, thus, it argued that having failed to obtain such relief, the appellant was compelled to file the present appeal. Another trigger for filing such appeal was that subsequently the interim order granted originally was extended, which has also been assailed in a different appeal, which is also pending before us now. Next para, learned counsel for the respondents opposes the contention and submits that the pendency of Order 39, the pendency of a vacating application cannot suffice as justification for preferring an appeal late against the parent order. It is argued that it was well available before the appellants merely to move an application for expeditious disposal of the vacating application before the appropriate bench of this court, or otherwise, to canvass its points in the vacating application itself instead of preferring the present appeal. Moreover, it is contended that Order 39, that the vacating application operates on a different footing as the appeal and cannot provide a justification for the delay in preferring the appeal. Next para, at the first blush, it is evident that the scopes of adjudication in an application for vacating, comma, having the trappings of Order 39 Rule 4 of the Code of Civil Procedure and a regular appeal against the ad interim order are different. Full stop, next para. Whereas a vacating application is limited to the tests as stipulated in Order 39 Rule 4 of the Code, comma, an appeal is in a sense wider in scope and all questions can be raised therein. Full stop, thus, comma, mere pendency of Order 39 and application under Order 39 Rule 4 of the Code might not be a sufficient justification for not preferring an appeal which could be preferred simultaneously along with the Order 39 Rule 4 application, comma, the remedies being different in nature. Full stop, next para. However, comma, there are two factors which prompt us to hold otherwise. Full stop, first, comma, in the present case, comma, the application for vacating does not strictly come within the ambit of Order 39 Rule 4 of the Code, comma, the code being not directly applicable to the paradigm of the Arbitration and Conciliation Act 1996. As such, comma, although certain identical factors may be considered by the court in a vacating application in respect of a Section 9, 1996 Act application, comma, the Order 39 Rule 4 tests are not strictly applicable. Full stop. Thus, comma, there is more commonality between a vacating application and an appeal against the ad interim order than in a proceeding under Section 39 Rule 4 and an appeal under Order 43, comma, both of the Code of Civil Procedure. Full stop. Since this is not a regular suit, comma, the rigors of the code do not apply per se, and as such, comma, the sharp lines of distinction drawn between an Order 39 Rule 4 application and an Order 43 appeal may not be applicable to an arbitral proceeding or applications to appeals arising therefrom. Full stop, next para. Secondly, comma, in the present case, comma, the ends which would be achieved by the appellants, either if the vacating application is allowed or if the present appeal is admitted and allowed, would be the same, comma, being the vacating stroke modification stroke variation of the initial ad interim order. Full stop. Hence, comma, although the means are different, comma, the end is the same. Full stop. Thus, comma, some justification can be attributed to the appellants waiting for their vacating application to be concluded, and thereafter, comma, when they saw that instead of the vacating application being decided, comma, the original ad interim order was again extended, comma, it might have sufficed to prompt the appellants to prefer an appeal against the extension order as well as the parent order, which they have actually done in the present case. Full stop. That apart, para. That apart, comma, the delay of 22 days is not much, and as such, a lenient approach ought to be adopted in such cases. Full stop. In such view of the matter, comma, can 2
This will be can 2, my lord.
Can 2 of 2026 is allowed, thereby condoning the delay in preferring FMET 130 of 2026. Full stop. The said application appeal is now taken up for hearing under Order 41.
My lord takes up the impugned order, 16th of February 2026.
Yes.
My lord, record is taken up for hearing by applicant under Section 9. My lord would next take the next paragraph, my lord. Kindly cease on or about, this would be, my lord, for 6th line in the second paragraph. On or about March 13th, petitioner came to observe several tenders were floated by the opposite parties for the purpose
One
of
second. Yes. On or about?
On or about March 2013, the petitioner came to observe that several tenders were floated by the opposite parties for purpose of provision of onboarding catering services in train number such and such for a period of 5 + 5 years, subject to satisfactory performance. On completion of 5 years, on renewal for a period of 5 years, on the terms and conditions contained therein, and tender period extended from time to time, and ultimately till is in force. Now, my lord, it is admitted, my lord, that the initial from 2013, my lord, they were successful tendering so far 2013 tender was concerned. Now, my lord, they continue for, my lord, two successive tenures, my lord. Now, my lord, kindly cease.
When was it due to last expire?
It was, my lord, the last renewal, my lord, was still 6/6/2024. 7/6/2019 to 6/6/2024.
6/6/24, it was to last expire.
Last expire, my lord. Now, my lord,
After that, there was no renewal.
no, there was no renewal.
Very well.
Now, my lord, kindly cease the next page of the, my lord, the second page of the order sheet, my lord.
Yes.
The period of contract was further extended for 2 years by the opposite party with effect from 7 June 2024 to 19th February 2026. My lord, kindly marks this. So, my lord, this is an extension, and I'll show, my lord, the
This is
reason
what
why
order
this-
number 3.
Page number 3, my lord.
Page number 3.
In fact, page number 2 of the order sheet, my lord.
Page number.
The period, second line, my lord, the period of contract.
Page number 1. Number 1.
The period of contract
Contract.
was further extended for 2 years by the opposite party with effect from 7 June 2024 to 19th February 2026. Admitted, my lord, kindly takes a note of this. Then, my lord, kindly sees it is pertinent to mention the petitioner has not received any complaint from respondent authority about the services provided by the petitioner in the said trains. During the tenure of the contracts of the said trains, the opposite party cancelled the round trips on several days for different reasons. My lord, held by scope. Then, my lord, kindly sees just the next line, my lord, the petitioner received information from the opposite party regarding the cancelled
You are the
trips.
authority. You are the tender.
Yes, my lord.
And you are the tender. I mean the bidder. Successful.
Successful bidder, my lord. Then, my lord, kindly sees the petitioner by letters dated 28/1/2026 requested the opposite party to extend the contract period for cancelled days as mentioned above, which the petitioner is legally entitled to as per tender, as the trips were cancelled by the opposite party. So this is the sum and substance of the, my lord. Then, my lord, kindly sees it was pointed out to next paragraph, my lord. It was pointed out to me during the course of submission by the learned advocate representing the petitioner that during the period the license subsisted in favor of the petitioner with respect to providing on-board catering service in the trains as enlisted in the award of license. Due to unforeseen reasons, number of round trips with respect to the individual trains got cancelled, and in order to know the exact figure, the petitioner made several communication to the concerned authority of the opposite party, and such communication spanned across a length of time commencing from 29/1/26 to 11/2/26. In all the communication, there was specific prayer ventilated by the petitioner that as the petitioner could not avail of the scope to perform the job of providing the catering services in the trains, owing to the cancellation for reasons beyond the control of the petitioner and not attributable to any laches or negligence on the part of the petitioner may be permitted to get those days of cancellation adjusted with the license period through extension of the contract. But surprisingly, the opposite party did not respond to such communication in black and white, and such a passive attitude has instilled an agony in the mind of petitioner that he may be deprived of the opportunity as prayed for by him, thereby amounting to the loss of the investment which has been effected by him in order to arrange for providing the catering services on a regular basis. This is the primal factor and the reason which has prompted the petitioner to ventilate his grievance before the learned court and praying for interim protection, so that his rights and interests is as exuding from the contract of license does not get weaned out for no fault on the part of on his part and without justification. It is very much significant to mention here that the petitioner has been failed.
Some extra pages come in between. That's why we could not follow. Certificate copy? How could this come in? The certificate copy, this was stitched. We've got a certificate.
It is very bad.
মাঝখানে টেক্সটে কথা ছিল
The follow up back specific. মিলছে না তো এর সাথে।
না এটা তো অন্য। What is this fee? How could this come in?
It is path express.
This is in a different texture of paper. This has no stamp.
এখানে
Both the copies it's there.
এইটা মিস
Which are-
Is it tallying, my lord?
No,
What
this
I'm
is a
reading-
different page altogether. The very next page tallies. This has come stitched in between. Both are copies.
This has been, my lord, obtained from the, my lord, the
Should not have
certificate.
been. This is not a stamp. This page is not
I
stamped.
appreciate, my lord, what's my lord's comment.
Anyway, let us follow the pages. We'll look into this later.
Yes, my lord.
But this, it continues from the previous page, how thereby amounting.
Yes, my lord, they were amounting.
Where will you follow from? Yes, please repeat that portion. No, we have heard you. So,
No, no.
investment affected.
Then, my lord, kindly then sees it is very much significant to mention here that petitioner has been fading with the information from reliable that the opposite party issued a fresh tender in respect of the said train sometime in the year 2024. And this process took place when the contract awarded to petitioner in connection with the said trains was in existence. To be more specific, as per averments of the incident petition, the new tender got opened on 15/4/2024. Now, kindly pause for a moment. This was 15/4/24. And, my lord, this application is being filed in 2026.
Yes, but the contract was valid till 6th of June 2024.
Yes, my lord.
Before that, the new tender was open.
I'll
You
indicate the
understand
reason.
2 years after.
Yes,
So
yes.
that's a different point. But this
The
also you have to deal with.
The attitude of the opposite party to float a new tender in subsistence of the earlier one conjunctively with the silence maintained by the opposite party in
You
replying.
can float earlier, but it has to be opened later.
My lord, it was opened, but it was given effect subsequent, my lord, to
You
the
find it
expiry.
from that tender.
That has not been annexed by them. In fact, my lord, where the point is, my lord, they had participated. And this I'll show from the pleadings in the application.
In the subsequent tender.
Yes.
New tender.
Yes. And I'll show it, my lord. And this is wholly absent in the impugned order, my lord. And I'll show the section 9 application, my lord. Then, my lord, kindly sees the attitude of the opposite party to float a new tender during subsistence of the earlier one conjunctively with the silence maintained by the opposite party in replying to the letter of request addressed by the petitioner, engulfed the petitioner with the trepidation of sufferance of a loss, thereby compelling him to seek the relief by invoking the provisions of section 9. Then, my lord, Supreme Court judgment has relied upon, my lord. Then, my lord, comes to the next page. I think the petitioner herein has succeeded in establishing the grounds to seek an interim protection against the opposite parties being the subject matter of agreement.
Mr. Vardhan, these are probably more legible copies. So probably the department insisted they are not at fault.
The department
Your
insisted
clerk
on
might have due.
They wanted legible.
They should not come inside the certified copy.
Well, I take responsibility. But
the department insisted, tell us. We'll have a talk with the department.
Department insist করেছিল
legible copy দিতে ওটা দিয়েছিল
legible copy was sought for, my lord, and this is how it is.
It's different. Legible copies.
I appreciate, my lord. My lord, I'll talk with them.
No, it's all right. Very well. But there was a deja vu when he sought the second page. So we found that the previous page has been repeated.
Then, my lord, kindly sees he finds.
I think that has succeeded.
Then, my lord, at this juncture, I think justice will be subserved if the OPs, their men and agents, associates are restrained from taking any further steps in respect of the new tender that was alleged to be opened on 15/4/24 when the license awarded to the petitioner on earlier occasion was in force, and such restraint will work upon the opposite party till instant miscase comes up for comprehensive adjudication, exchange of pleadings. OP men and agents restrained from taking any further steps in respect of the new tender that was alleged to be opened on 15/4/24.
You have already granted a contract in terms of that.
To someone else, yes. No, that is also not the application.
That is also probably is going to half of that is over now.
I am suffering damages against that.
Now you understand why Mr. Puttu was taking the jurisdiction point.
Not the jurisdiction, my lord. Section
No, our determination.
Oh. Now, my lord, most importantly, my lord, now kindly takes up the, my lord, section 9 application. My lord, section 9 applications are one page 166, my lord.
Posthumously মারা গেছে সেই কন্ট্রাক্ট সেটাকে এখন
Now, my lord, the section 9 application has been annexed, my lord, 166 on volume 2 of the stay application, my lord. Now, my lord, the section 9 application has been annexed, my lord, bereft of the annexures, my lord. And insofar as we were advised to, my lord, file legible copies, my lord, we could not in the short span of time, my lord. So we have copies. The entire section 9 application. My lord, these are other documents as well. A part of these of the annexures, my lord. But this is the, my lord, the section 9 application with annexures, my lord. Brief করেছিস? Well, we have crave relief. I'm told we have crave
মানে
relief.
with annexure relief করা আছে without annex করা আছে।
Some of the annexes we have annexed.
Some of the annexes which I take responsibility, which I felt should be looked into, we have annexed. But this application has to be taken out. Now kindly seize the application at page 16, the application as to what is the dispute and what is the
The
pleadings.
paragraph so that you can follow.
Paragraph 7. Page 3, paragraph 7.
Yes.
Letters of third line, letters of award were issued on 21/5/14 for 5 years by the opposite party. So this was the first the first period. Then kindly seize para 12. Your petitioner states that after successfully completion of the initial period of 5 years, petitioner applied for renewal of the contract for a further period of 5 years. So 10 years expires. Now kindly seize paragraph 13. Your petitioner states that the period of contract was further extended by 2 years by the opposite party with effect from 7 June 2024 to 19 February 2026.
Provisional. This was extended provisionally.
No, there was, kindly view this. In the second term, the COVID intervened. So, there was an agreement which we call as the Dias non-agreement, which appears at page 64. Kindly seize page 64 of this application. Kindly seize
This was for the lost period.
Yes. Kindly seize the page 65 seize. Seize the third paragraph from the, in fact, fourth paragraph. Whereas pursuant to resumption of cooked food, the master license agreement was restored. The period from 22/3/2020 to resumption of contract may be treated as Dias non-period. Then kindly seize, now this agreement witnesseth. This agreement shall come into force on June 7, 2025 and shall be subject to the provision of earlier termination provided in the earlier master's license and shall be valid up to 19th February 2026. So this is the date of 19th February 2026. Till when,
No, if you extended this from June 7, 2024, how could you parallelly give it to someone else?
No, I have given to someone else after this date. Effective date of the tender, to someone else.
So that 2024 tender was given effect after February 9th?
Yes.
ওইটাই 19th date ছিল।
Yes. Till 19th, he was enjoying the tender.
So therefore, he's coming up after this period, after 2 years, that loses the sting it had.
No, because
so
this agreement,
because cause of action starts after this is over and the new.
No, because the tender was opened in 2024.
Right.
And I'll show the pleadings.
So what does he challenge in the?
I'll just show that.
The main dispute, what has he raised?
I'll show that.
This is section 9.
Yes, section 9. Kindly seize the dispute. Para 25. That would be at page 171. Till the publication of new tender during the existence of the present contract in respect of the said claim with the opposite party is totally bad in law and liable to be set aside.
No, his contention is that apart from this agreement which you entered into with him in any event for the lost period during COVID,
participated
for the lost period during COVID, he's also entitled to the further period during which he was not responsible, but you had cancelled this.
That was during the COVID period.
COVID period itself.
Yes, and I'll show his letter. I'll show his communication.
Does he specify the period for which it was cancelled?
I'll show the letter,
in the section 9.
Yes, he's annexed that. But kindly for the present, kindly comes to page 20, para 24 at page 6 once. Kindly sees that your petitioner states that a petitioner from reliable source came to know that the opposite party issued a fresh tender in respect of the said trains during existence of the present contract, and the said new tender was opened on 15/4/2024. As such, petitioner apprehends that the said train to be handed over to a third party, and if the opposite party is successful in their ulterior motive, your petitioner will be suffered. The petitioner take part in the tender. So, he was an unsuccessful participant. So, 2024 tender, he participates. Unsuccessful. And then Mullet kindly takes the trouble of Mullet the relief sought at page 10. This, as I say, Mullet is a circuitous way, Mullet, of Mullet attacking the tender. Injunction be passed directing the opposite party to allow the petitioner to continue the catering services in train number such and such for 589 days as per tender for cancelled days, round trips. And or an order of injunction be passed restraining the opposite party, their men, agents, and associates from handing over, transferring, assigning, and or creating third-party interest in respect of the train number such and such in any manner whatsoever. It's a blanket injunction. Let's see. Then Mullet, the letter by which this sought extension. Mullet, that would be Mullet, page 113. So Mullet, after having enjoyed Mullet and derived the benefit of that subsequent agreement for 2 years, in the agreement for the non-dias period of 2 years, in 2026, Mullet, on 29th January, they issued the letter. With reference to the above subject mentioned above, this is to inform you that train number such and such were cancelled and or short terminated during the period mentioned below. Train cancellation details.
This was after the COVID period.
Yes. Now, Mullet.
No, this cause of action arose only subsequently.
No, Mullet. Why I say this, Mullet?
Subsequently.
No, Mullet. The initial Mullet for 10 years was till 2024.
Mr. Borden, we are saying things against you so that you can answer. By virtue of this second contract, what was done was this diational period was given. The effect is extension of the original contract period. Because it's that contract which you are extending by deeming it to continue up to this date. So therefore, it was a deemed continuation of that previous contract which was going on. Now, during this period, subsequent cause of action arose. Certain trains were cancelled unilaterally by you. They had no control.
No,
this
Mullet,
is 24, 25, 24.
Now, Mullet, I'll show the dates of the cancelled trains.
He has given the dates.
No, Mullet, it is not this, Mullet. Kindly bears with me, Mullet.
Short terminated date is given.
Mullet, kindly sees train cancellation details and short termination details. So this one cancellation and this short termination. Now the cancellation details, Mullet, would come at page Mullet 118. Kindly seize, Mullet. 22nd March 2020. That's the Mullet, the first column. In fact, the second column, Mullet.
Page 118.
118. In fact, sorry, Mullet, 1126. These are the trains which they allege to have been cancelled. Kindly seize, Mullet, 22 March 2020. Seize, Mullet. Kindly, Mullet, traverses to the right under the remarks column due to COVID-19 and Janta curfew 22/3/2020. Now, Mullet, this continues till page 200. Serial numbers 1 to 558.
This includes the dish banging period also.
Yes. And then, Mullet, pandemic period is from serial number 1.
Continue after this is from the pandemic period.
The Lordship had kept this supplementary list.
List, yes. Supplementary list.
There is one typographical error in paragraph 4.
Yes, yes. Take it.
Madam,
yes.
But in paragraph 4, that is part of this Lordship had recorded the argument made by me.
Yes.
So that part, the Lordship has recorded the outgoing president, that is a typographical error. That is part of my submission, not part of Lordship. Not part of Lordship's order.
Paragraph 4, second.
Paragraph 4. Outgoing president, that will be wrong. It should be non-member.
Non-member?
This is part of my non-member. That was part of my argument. That is not court's finding.
But I have informed the other side by phone.
Who was appearing for them?
Devulinam Chakraborty. Her name is recorded in the order. She is the advocate.
This is part of my argument also, not part of court's finding. I cannot touch anything which is court's finding. And this is from the plaint case also. She was not the outgoing president, was Manju Periwal. Factually also that is not correct. Outgoing president was Manju Periwal, and she was one of the past president, and presently we are saying non-member. So this is only part of my argument with lordship recorded. This is not part of the court finding.
It's pointed out by learned senior counsel for the appellant that in the order dated May 19, 2026, in paragraph number 4, it was erroneously recorded as submission of the appellant that the plaintiff was an outgoing president, whereas it was argued that the plaintiff was a non-member. Accordingly, in the said order dated May 19, 2026, in the second line of paragraph 4, instead of double inverted an outgoing president, P capital, double inverted close, it will be recorded as double inverted with a non-member, double inverted close. Let the said order be deemed to stand corrected accordingly.
But another matter, in the page 44 of my stay application of the memo, but there was in the plaint, there was a pro forma defendant. I have inadvertently not included in the appeal cost settlement. Leave be granted to include the pro forma defendant in the appeal cost settlement.
The appeal was disposed of, no?
No, pending.
No, it's pending.
On the prayer of the appellant, leave is on the prayer of the appellant, leave is given to the learned advocate on record for the appellant to rectify the memorandum of appeal and the connected application by incorporating the name of the pro forma respondent.
Deeply obliged, ma'am. I apologize for the inconvenience.
You are going to say something?
Your Lordship,
I remember you, but
I'm an admirer of yours. I just came to pay
after this,
my respect because anytime I remember you, I always hear you, and I really admire you. I'm also a school friend of one of your colleagues, Justice Sanjeev Banerjee from St. Paul's School. And you had dealt my matter also.
Thank you very much.
I came to pay my respect, and I highly admire you.
Thank you very much.
Grateful.
Sorry, we're a bit late. Mr. Bordon, we find that their claim was not only on the basis of the cancellations, but also probably on the short terminated dates.
Well, kindly see the letter. The letter is page 113.
Yes.
It kindly comes to page 117. In view of the above, we respectfully request the extension may be kindly be granted for the same number of trips as were cancelled earlier, so as to compensate for the loss incurred due to the said cancellations. Let I pause here for a moment. Kindly marks the word compensate for the loss incurred.
Yes.
Why is this language, my lord? The language is this because, my lord, the parent master license agreement, which would appear from page 89 of, my lord, the stay application. This, my lord, is having a look at, my lord, the section 9 application. My lord has a look at the stay application, my lord. My lord, first volume of the stay application.
Oh.
Page 113, my lord.
89.
It starts from page 89, my lord. The relevant portion I'll be placing, my lord.
This also 113.
113, also 113.
Yes.
Article 19, cancellation, withdrawal, non-operation of the train and refund of license fee. In the event of permanent cancellation, withdrawal, non-operation of a train service by the railways, this agreement shall be terminated without any notice or assigning any reason to licensee. In such an event, the licensee shall be refunded. The license fee shall be refunded to the licensee on pro rata basis. So,
permanent cancellation.
Kindly sees cancellation, withdrawal, non-operation.
Why the word permanent?
In the event of permanent cancellation, then oblique.
Permanent cancellation is one phrase.
One. Then oblique, withdrawal. Then non-operation of the train service.
There was an oblique motive here.
So that is the reason, which prompts them to write in the letter, dated 29/1/2026.
Relief could lie in compensation.
My contention is, the relief is as in by way of damages.
All right.
So that could be the dispute in the arbitration. So, section 9, the relief sought for in the section 9 application, cannot be expanded to overreach the final relief. So, the relief is as and by way of damages. Number one. Number two, this contract, is in the nature of a determinable contract.
What contract?
Determinable contract, termination. Would see, page 111, that's termination clause, it as page 111, termination. So, in such sort of a agreements, remedy lies as and by way of damages and no injunction. Then number three, admittedly, there was a tender.
No, let us see the termination first. If either by party is subject to the...
I mean to say that it is terminable at the option of the parties.
No, under certain circumstances.
Yes, kindly see 18.4. I could have terminated now. Once the agreement has come to an end, does it lie in their mouth, to seek an injunction in the nature of upstaging the entire tender process? Admittedly, third-party interests have been created way back in on 15/4/2024. That is the date of the earlier
Letter of award.
No, the tender. The letter of award was on 15/4/2024. Now this was entirely suppressed. Now I would have taken the point of suppression in the lines of Bengal Club, but has referred Bengal Club to a larger bench. So probably I will restrain myself from beginning submissions on that scope. But even otherwise, now the issue today, is in 2024 they were the unsuccessful tender. Now they wait till 2026 to file this. Now, the learned judge in the court below is alive to this. The question I posed to myself is, what was the impending urgency to pass an interim order of injunction? He could have very well directed service, even Dusty service. Because my lord, he ought to have been alive to the situation that the tender was in 2024. And there's a categorical averment that he participated in the tender. He says nothing further. So, my lord, the consequence would have been twofold. Either, my lord, he was successful or he was not successful.
But his tender was deemed to be extended till February 26.
My lord, till February 26, I've got no problems, my lord. Till 19th February 2026, I've got no problems. He seeks an extension from 19/6/2026.
His cause of action for that arises after that. Why not after that? Because till then he was already enjoying the fruits of the contract, the contract itself.
My lord, he was
that contract itself was what was extended.
My lord, I bow down, my lord. Now, my lord, kindly sees the
contract ends, and then only the question of your giving effect to that.
My lord, he was aware of me giving effect to the contract way back in 2024. 15th April 2024, my lord. And the learned judge ought to have been alive to the situation that since there was tender, there ought to have been a successful tenderer. So some third party interests might get affected by this order. And kindly sees the blanket order. Further steps in respect of the new tender. No, the interim order, my lord.
Yes.
Further restraint from taking any further steps in respect of the new tender that was alleged to be opened on 15/4/24. So the learned judge is aware that there was a tender that was opened on 15/4/2024. So, my lord, he ought to have put us on notice, at least to verify whether any third-party interests have been created or not. And, my lord, this, again, my lord, this also, my lord, by the fact that they themselves have in their application said that they participated in the tender and nothing further. That part, my lord, would kindly comes to page 113 as I was showing, my lord. They are only seeking extension in respect of, my lord, the cancellation. My lord, I do admit that, my lord, the list that they have, my lord, shown from serial number 1 to 558 and subsequent, there are certain, my lord, trains which have been cancelled for the period subsequent. I admit that. But in that event, my lord, his claim could at best have been limited, my lord, to the cancellation of trains subsequent to the period of the non-dias agreement. He seeks a blanket order for all cancellations of which, my lord, he has derived the benefit.
No, under the cancellation list also there are certain trains which were cancelled after COVID
Yes,
period.
yes, I'll show, my lord.
If you're saying because that's against you, if you're saying we'll
My lord, it starts from serial number 1 to 579. 1 to 558 were during the pandemic period. That's page 118 to 200. Then 559 to 579 is the subsequent period. So, my lord, those 20 cancellations is subsequent, my lord. Then, my lord, would kindly sees the next letter, my lord, page 204, my lord, of the section 9 application. This would be, my lord, the second last page, I guess. Oh. 204. Section 9, last page, my lord. It's after 203. This could be, my lord, the second last page of the section 9 application. My lord.
Volume, which volume?
My lord, section 9 application is only one volume. Handed over. My lord, this is dated 11th of February 2026.
Yes.
My lord, sees the last paragraph.
Letter. This is another letter.
Another letter. Kindly sees the date again, February 2026. Now, my lord, kindly sees, therefore, you are the last paragraph. You are hereby requested to allow me to continue the catering services in train number such and such for 589 days. It is not their case that they want an extension so far as the subsequent period is concerned. They want the extension for the entire period, a majority of which, my lord, they have already enjoyed the fruits in terms of the, my lord, the rider agreement, of that's the dias non-agreement. So, my lord, first, as I say, my lord, the remedy lies in by way of damages. that could be, my lord, and that, my lord, is to be adjudicated in the arbitration proceedings, my lord. Section 9 relief, as it has been couched, my lord, is, my lord, in the widest possible amplitude. And, my lord, would again, at repetition, my lord, I must say, they seek an injunction in respect of creating any third-party interest. And I say, my lord, third-party interests have already been created. And, my lord, they were alive to the situation that, my lord, third-party interests were created on 15th of April 2024. And they wait till, my lord, February 2026 to file their application seeking an ad interim order. So there was no urgency worth the name for the learned judge in the court below to have passed this order on these terms, my lord. Those are my submissions so far as this, my lord, appeal is concerned. My lord, I have the copy of letter of award, which was given, my lord, to a third party, RK Associates. This is dated 15/4. But since this is not on record, my lord,
it is an admitted position that the contract tender was opened. That is an admitted.
Yes, now it has been given to someone. Now, my lord,
contract has been awarded.
Yes, I have the documents, my lord, but since
give it to you for the time. Yes.
Now, the procedure which is followed in these kind of cases is that there's an agreement which continues, and the agreement of the operator is given some extensions, some exclusion periods, those are extended. So, in the meantime, the railways already does a tender, issues a contract, but does not give effect to the commencement date. So, what my learned senior friend is saying, it's a fact. I am not disputing that. But that did not commence. My lord, why is that? My lord, if your lordship kindly sees the agreement with the 3 renewals which has been given to me, kindly takes a look at, my lord, the first renewal, which is at page 183, the volume which my learned senior friend just now showed, possibly 183, my lord. No, not the section 9, the volume 2 of the stay application.
(183) of the stay.
Of the stay. Volume
2, Babe.
Volume 1. PDF page is 134. 133, my lord. I'm sorry. 133. P is very. Volume 1, my lord. Volume 1, 133.
Yes.
So, my lord, this is granted on 5th of November 2019. So, my lord, this is from 7 June 2019 till 6 June 2021. The first extension. Then, my lord, the second is page 136, which is, my lord, till 6 June 2024, which your lordship will find in the third line. So, my lord, this date is important, my lord, 6 June 2024, because already within the extended period, the new tender is floated, which is sometime in April 2024. So, my lord, it is also an admitted position that I had bid for that. But I was not the successful bidder. But I bid for that. Now, my lord, here the contract is extended till 6th of June 2024. Now comes the first rider agreement, which my lord will find in the next page 137, which extends it, my lord, for a period till 6 June 2020. This is the rider agreement, 6 June 2024. Now, the second rider agreement, my lord, is at page 144. This, my lord, will find is a rider agreement for dies non period. But this really kindly comes to paragraph 4 at page 145. This really is the COVID period. Paragraph 4 really is with respect to the second sentence, the period from 22/3/2020 to resumption of contract may be treated as dies non period. So, this exclusion, or no, I'm sorry, this extension is only for the COVID period. So, what happens is I have to give them license fees upfront, and they will.
Can you get same benefit for the same period? I mean,
no, I have not claimed that. No, I have not claimed that.
Some of your cancellation lists, most of them are of 2020.
But could I show from that? Not because the days calculation I have given there. So your lordship has seen that from 22 March 2020 till the resumption, and kindly sees the clause number 1 thereafter. It is still 19 February 2026. But the order impugned is dated 16th of February 2026, and this period is till 19th of February 2026. So before that, the order, but we write the letter of 11th of February in this. Now kindly sees my demand for the extension application. Page 260. No, I'm sorry. No, that's it. But section 9 application is, my lord, kindly takes a look at. No. 113, my lord. Your lordship would kindly see the dates. My lord, this is of 2024-2025, first page. Thereafter, my lord, second page also that.
Page 113.
Third page also that. Fourth page also that.
113
of the section 9 application. I'm sorry, I'm really sorry. The one which my learned senior friend handed over. And my lord, till page 117, your lordship would find all are 24-25.
These are short terminated dates.
Yes. So my lord,
short termination.
I'm sorry, my lord.
Short termination,
Yes.
not cancellation.
Yes.
Because you have given separate lists for both.
Yes. Now, your lordship would find that all these are for the period 2024-2025.
But then you give a summarization of that at page 117. Short terminated, total trip cancellation and short terminations. And you make your claim on the cancellations. Please explain that to us. Page 117. In view of the above last bullet points after the chart. Total trip
If your lordship sees before the chart,
yes,
it says 580 trips and train number such and such, these are cancellation. And when short termination are these.
Yes.
So, my lord,
the short term, the cancellations are annexed separately. 118 is a continuation of that letter.
Yes.
Yes. Rescheduling details are attached separately in Excel format.
Yes. So, my lord, if your lordship kindly sees.
So, you ask only for the cancellation period, not the short terminations.
118 onwards, these are possibly the cancellations.
Yes.
So, my lord, if your lordship kindly sees till 125, subject to correction, my lord, this is all 2025 for 2025, 2026.
The cancellations also.
The cancellations. But, my lord, the one which has been shown from page 126 also by my learned senior friend, though that is, my lord, for the entire period from March 22, 2020 till, my lord.
So there's an overlap between the periods for which you already got a non-dice agreement.
But possibly not, because of these cancellations is for the period 2024 to 2026.
Have you stated that? Because you have referred to Excel sheets, separate Excel sheets. Although the Excel sheets.
But I was told that this.
So Excel sheets end at page 125.
125. And these are their documents. I'm sorry.
Your claim ends at page 125. I mean, that is the last cancelled train up to which you claim extension. Then what are the page 126 onwards also are there? This is your section 9, not their document.
Yes. These were given by them to us with all the details from the period where I got the non-dice agreement also and the subsequent period also.
But your claim was till page 125 chart.
My claim was, yes, it's only till this period. This is what I understand, but I could be subject to correction.
You also have to understand others. It's not clear from your letter.
Because, my lord, if your lordship kindly sees the first page of the letter.
Both are Excel sheets.
If your lordship kindly sees page 126, kindly sees the heading, It is the entire period is given here. 28 January 2019 till 29 January 2026.
If you have annexed that to your letter, to your section 9 also, then you
Yes.
claim for that period also this extension.
But my claiming is not, I have got the extension, I have paid the license fees for that, for the non-dies period. But I am claiming extension for the cancellations, for which I have not been given before, because your lordship, if my lord kindly sees that agreement at page 145, that is only for that period. Because my lord, for the subsequent period, my lord,
No, only
if
for
I,
that period.
if I could pose in a question form with my lord's kind indulgence, how could we have been given an extension in 2024
No, we
or
are
something in 2025 and
not,
2026?
they are agreeing to that, and we asked them also. Dies non was for the COVID period.
So,
you cannot ask double extension
I
for the
cannot.
COVID period.
I cannot ask
You are
double.
saying you are not asking that.
No,
You are
I am
asking
saying
for
I'm not asking. I am asking for the subsequent period because I have got till the 2024. Now, what prompted me to come there? Because an impression was given, which your lordship also frowned upon a bit, that why in 2026 I have come when I have admittedly said 2024 contract. But as it fell from your lordship, that the effect of that was not, my lord, troubling me because I got the extension till 2026 February.
Mr. Gupta, the tender process had already taken place, and the
Right.
cause of action is on 24.
Right. So still, I had the extension till 19
The
February
extension,
2026.
but that extension is on a completely different footing than the
Right.
tender.
So that third party contractor has still not got the start, has still not got the go ahead for the contract. So it's like he is being deferred for a while before he can come in. Because I have already paid the license fees and I have not got.
Your challenge is to an act which happened in 2024. Why didn't you challenge at that point of time?
But
You
because-
obtained one dies non. You could have at the same time asked for simultaneous extension.
But because I had prayed for an extension beforehand also, but I for this period I could not have claimed in
Because,
2024.
Mr.
But 2024.
So your contract will never end. Subsequently, there will be cancellations.
Could I just
You are the
indicate one thing
only
in
monopolist who will
2024?
be carrying on.
But that is
No, that cannot be. I mean,
that
it
cannot.
cannot
But
be
if your
the
lordship kindly
law.
visualizes in 2024, I
So,
could not
if you grant if you get a remedy, if you're granted a relief in a arbitration, even then after that also, when your contract continues, then there will be further cancellations. Your contract will go on forever. Then there won't be any tender process. That cannot be the law, because the law, your contract specifically stipulates a remedy for that, which is in damages, compensation. Mr. Bordhan relied on that provision. Some clause at page 113.
But
so therefore, it's that your remedy lies in compensation for cancellation of
But
claim.
this is also really in the nature of a specific performance.
COVID was.
It's also in the nature of a specific.
It will never end. Your contract will perpetually go on. There will be some cancellations definitely. Your contract will go on. That's why the contract contemplates compensation as your remedy. Compensation, the specific remedy is given in the clause.
But I understand that. But only one thing. But if your lordship kindly, apropos what fell from your lordship just a while back, that my lord, why in 2024 I did not challenge?
Yes, you should have.
Yes, but possibly, my lord, I should not have, possibly, subject to my lord's kind interpretation. Is, my lord, I did not know of the cancellations of 2024, 2025, 2026
That is what we are
in
saying.
2024.
Then
So I
whenever
could have challenged.
No, your contract cannot be perpetuated like this. Whenever there will be cancellations, you get another day. One cancellation, another, add one more day. This cannot go on forever. That would be an absurd interpretation of the contract.
But that is why
a contract for a specific period, dies non period given due to the COVID extension. Supreme Court was also granting those extensions. Everything had an extended lifespan. You can understand that. But for every cancellation,
Because
the agreement does not contemplate an extension of the contract for cancellation. You are rewriting the agreement.
No, but we are not rewriting the agreement, but
agreement says you have a remedy. Agreement contemplates of cancellation and says that you are remedializing compensation. Go and get compensated. You are asking for an extension. This injunction cannot be in aid of compensation. That is page 113 or 11.
113, my lord, of the
section 9.
Section 9.
Yes.
In fact, my lord, 113 of the, my lord, stay application. There always there could be a corresponding page in the section 9 as well.
Very well.
113 of the stay application.
Yes, yes.
Article 19 to be precise.
Yes.
The last sentence of 19.1 is possibly your lordship indicating.
Yes. No, but you may have a point, Mr. Gupta, that it says this agreement shall be terminated without any notice. In that case, you will be refunded the life. They have not terminated as such.
They have not, there's no complaint against me.
Expired.
But there's
No, no.
never been any
19.2, what is that? Except as otherwise provided in this article, they
I
shall
have not
not.
make a claim for any consequential loss.
So
of
that
this-
implies that 19.1 also contemplates. Because apart from that, you won't have any other consequential loss or business damages due to permanent cancellation. So only if your contract is cancelled, so you're precluded from making any other claim also by virtue of this.
Yes.
For compensation also.
For compensation. But my
Where
contract
do you
is
get
not
this get this provision that your contract should be perpetuated whenever there is a cancellation? The agreement does not contemplate any such thing. Cancellation of trains will happen every day. I mean, not every day.
Yeah,
but I mean,
can happen every
frequently happens.
Can happen
I mean,
frequently.
for several reasons. Cancellations are a part of railway services. So then one person will carry on forever, and the agreement does not contemplate that there is a reason for that.
Could I kindly
No, don't come
back tomorrow, my lord?
Don't come back. But
Because
for
I
different-
have not even
No,
had
every time you ask you a question, you cannot come back.
no, but
Every time we ask you a question in any matter, you say, I'll come back. Come back, but
this really takes away my case for specific performance.
tomorrow also another question will crop up and then you will come back. No, you answer right now. It's there in the agreement. You are asking the question, you have to answer. You have to think on your feet, Mr. Gupta.
No, it's not really.
We are reading the agreement only. Show us the provision which permits an extension. Your claim is the very basis of the claim is the agreement. Your claim is that your contract should be perpetually extended whenever there is a cancellation. That cannot be the law or any rational interpretation. যদি এগ্রিমেন্টে থাকতো যে হ্যাঁ এরকম যদি ক্যান্সেলেশন হয় তাহলে আমি এক্সটেনশন দেবো আলাদা কথা কোথাও কিচ্ছু নেই পাওয়ার তো রয়েছে এখানে পাওয়ারের প্রশ্ন নেই কারণ এখানে তো অলরেডি সাবসিকুয়েন্ট টেন্ডার ফ্লো হয়ে গেছে তাতে পার্টিসিপেট করে হেরেছেও এরে তারপরে এই অ্যাডভান্টেজ নিয়ে এতদিন কিন্তু তার পরের ক্যান্সেলেশন গুলোর জন্য চাই অথরিটি ডাজ দেন নাথিং ক্যান বি সেড অথরিটি দেওয়ার প্রশ্ন নেই এখনো পার্টিসিপেট করে হেরে গিয়ে অন্য লোককে অলরেডি সাকসেসফুল বিডার হয়ে গেছে বাই ভার্চু কন্টিনিউ অথরিটি উই আর রিরাইটিং দ্য কন্ট্রাক্ট নাও হোয়াট ইজ দ্য পাওয়ার অফ দ্য অথরিটি অথরিটির আর কোনো পাওয়ার নেই তো অথরিটি তো কমপ্লেন যারা থেকে ক্লেম পেয়ে যাবে সাকসেসফুল টেন্ডার তার কাছে ও তো অলরেডি টেন্ডার প্রসেস নতুন ইনিশিয়েট করে তাতেও পার্টিসিপেট করে হেরে অন্য লোককে টেন্ডার সাকসেসফুল বিডার বেরিয়ে গেছে এটা শেষ হবে তাকে দিয়েছে এটা কতটা মেয়াদ Yes, Mr. Gupta, there is nothing in your nothing in your agreement and your matter.
Nothing in the agreement.
Because we are then rewriting the agreement. We cannot do that.
I was only looking at it from this point of view that my entire claim for specific performance would go in a section 9, possibly because the entire reliefs would go. Then my claim would only be limited to damages.
We'll turn down your entire claim and say this is tentative finding. What do you usually do in injunction? You have invited the court to do this.
But I did.
No, not you. You means your client of it.
But we had applied in January, previously also. Then we again apply in February. But there is no reply from their end also. So today.
They need not. There is no compulsion on them to reply. Anything and everything need not be replied. If you have a right
in contract.
In pursuance of that right you have written, then they are due to go. Suppose renewal clause, there's a renewal clause. Not in this case, but that is not backed up by any right. Your writing is not backed by the other right. I mean the other spelling right. But if you have written, they have not answered.
But the fact that there were cancellations is eminent. That is an undisputed position. So
you don't know whether undisputed at this stage because it's added.
Because my entire claim is based on the documents supplied by them. This I also annex with this.
Whatever you say, that is the premise of the ad interim injunction. We have not got their version at all.
Well, these cancellations are from their documents.
You say that. You say that it's there from their documents. You produce the documents. They have not yet come on board by saying that these are my documents.
They filed the written objection also.
They have filed the written
Yeah.
objection.
Everything.
Filed an order and rule for vacating application.
Anyway, they filed some version, but we cannot look at that.
সেটা হিয়ারিং এর জন্য কনক্লুড হয়ে গেছে ওখানে
Hearing concluded.
লাস্ট অর্ডার
So we'll give Mr. Chaturvedi a chance now. We'll finish the matter. He's waiting eagerly, so we should give others a chance.
After vacation date.
এই যে দেখো লাস্ট অর্ডার they have exhausted this objected to repeating আমরা ভুলেও গিয়েছি বলাও কমপ্লিট হয়েছে আমাদের বলা বাকি ওখানে কমপ্লিট হয়ে গেছে
হ্যাঁ ওদের বলা হয়েছে আমাদের বলা হয়নি সেটা
এই মেঘনাথ ছিল না আমাদের স্কুল গেছিলাম
Yes. So it is the right time to start passing the order.
Not only kindly keeps this as a
As a?
as a tentative file.
Have to.
Because
We
otherwise
say everything, but say everything is tentative. Take your seat, Mr. Gupta. If you factually something is wrong, please just point out. Both of you. The present challenge has been preferred against an order whereby an ad interim injunction was granted in an application filed by the respondent under Section 9 of the Arbitration and Conciliation Act 1996, whereby the appellants herein and their main agents and associates were restrained from taking any further steps in respect of a new tender that was alleged to be opened on April 15, 2024, when the the license, clause awarded to the petitioner stroke respondent on an earlier occasion was in force. First up, next paragraph. Learned counsel appearing for the appellant's authorities argues that the tender is in respect of catering services for the railways. Full stop. Next para. In the application under Section 9, the cause of action espoused by the petitioner stroke respondent was apparently seeking an extension of the contract in that regard awarded to the petitioner stroke respondent for the period calculated on the basis of cancelled round trips of trains. First of next para, learned counsel argues at the outset that the initial contract awarded to the present respondent was renewed once and expired on June 6, 2024. Full stop. However, thereafter, taking into consideration the restrictions during the pandemic period, a DIES-NON agreement was entered into, whereby the contract was further renewed till February 19, 2026. Full stop. Next para. Immediately prior to the expiry of the said extended period, the present respondent wrote to the appellant authorities on January 29, 2026, seeking an extension, which was the premise of the Section 9 application. Full stop. Next para. Learned counsel argues that the tender was admittedly opened on April 15, 2024, but the respondent waited for 2 long years and immediately prior to the expiry of the extended DIES-NON agreement, came up with the said claim. Full stop. Thus, equities are balanced against the respondent. Full stop. Next para. Secondly, the petitioner stroke respondent participated in the fresh tender floated after expiry of the original contractual period, that is June 6, 2024. Full stop. It is submitted that although on paper, the said fresh tender was floated prior to the expiry of such period, the same was not given effect to during the subsistence of the contract with the respondent. Full stop. However, comma, the entire tender process was concluded upon opening the tender on April 15, 2024. Full stop. The respondent, comma, having participated and turned out unsuccessful in the fresh tender, comma, cannot be permitted to reopen the said chapter after 2 years. Full stop. Next para. Learned Counsel then places reliance on the documents annexed to the Section 9 application along with the letter dated January 29, 2026, from which, comma, it is argued, comma, it appears that there is an overlap of an extensive period during covered by the pandemic, comma, which was taken care of by the Dice-Non agreement, comma, also which has also been made as a premise of the claim of cancellation. Full stop. Such double benefit, comma, it is argued, comma, cannot be claimed by the respondents during the COVID period. Full stop. Next para. It is next argued by the appellant that the contract is determinable by nature, comma, which appears from its various clauses, and as such, comma, the remedy, comma, if any, comma, lies in damages for the respondent. Full stop. Next para. It is also contended that third-party rights have been created in favor of the successful tenderer upon opening the fresh tender on April 15, 2024, which cannot now be curtailed by the respondent. Full stop. Next para. Learned Counsel also submits that the agreement between the parties does not contemplate any extension of the contract period on the ground of cancellation of trains, full stop, by relying on clauses 19.1 and 19.2 of the original contract, comma, it is argued that at best, comma, the relief of the respondents on such count lies in compensation stroke damages and not an extension of the contract. So next para, thus, comma, it is submitted that the learned judge taking up the Section 9 application erred in law and in facts in passing the ad interim order. So next para, Learned Counsel appearing for the petitioner stroke respondent contends that the gap of 2 years, comma, stressed on so much by the appellant, comma, is a non-issue, comma, since by dint of the extension given through the non-dice agreement, comma, the contract was due to expire on February 17, 2026, comma, immediately prior to which the claim has been made. Full stop. Next para. It is argued that as per the provisions of clause 19.1 and 19.2, comma, if there was a cancellation of the agreement, comma, the respondent would be entitled to refund of license fees. Full stop. However, comma, the said clauses do not speak of any compensation for mere cancellation of trains, comma, without any such termination. Full stop. Next para. Learned Counsel appearing for the respondent further submits by placing reliance on the annexures to the letter dated January 29, 2026 issued by it, that the period for which the claim has been made is post-COVID period. Full stop. As such, comma, there is no overlap between the Dice-Non agreement tenure and the claim. Full stop. Next para. The extensive list of cancellations, comma, annexed to the Section 9 application was merely a document furnished by the railway authorities themselves for the entire period, comma, covering the COVID period as well as the subsequent period till recently. Full stop. However, comma, the claim of the respondent was restricted to the Excel sheets relied on by it, comma, which are confined to the post-COVID period. Full stop. Next para. Thus, comma, it is argued that the learned trial judge was justified in passing the ad interim order. Full stop. Next para. Upon a perusal of the agreement between the parties, comma, we do not find within the four corners of the same any provision of extension of the contractual period in the event of cancellation of trains. Full stop. Next para. At the best, comma, clauses 19.1 and 19.2 of the contract may be interpreted, comma, subject to being decided by the appropriate forum, finally, comma, to confer some right of compensation to the respondent. Full stop. However, comma, there is no provision of extension of the contract as indicated above. Full stop. Hence, comma, in order to grant the claim of the claim made by the respondent in respect of extension of the contractual period for cancellation of trains, comma, the contract would have to be rewritten, comma, which has been deprecated time and again by the Honorable Supreme Court and different high courts of the country. Full stop. Next para. Even otherwise, comma, the court or the arbitral tribunal, comma, if the matter goes to arbitration, comma, cannot carve out a right which is absent in the specific terms of the contract between the parties. Full stop. Next para. Even otherwise, comma, the effect of such an interpretation of the contract would be disastrous, comma, since a single contractor would then perpetuate his services without any opportunity being given to others in a transparent and inclusive process of tender. First of all, we say so because there are frequent occasions of cancellation of trains for various purposes, and if the same is deemed to give a right on a contractor to for extension of the contract of supply of food in railways, comma, the contract would never end and would be perpetuated forever. Push up. It is for such reason that no such clause has been incorporated in the contract between the parties. Push up. Next para. Even otherwise, comma, the effect of the impugned order would be that the valuable rights accrued in favor of a third party, comma, that is the successful bidder in the fresh tender, comma, the bids in respect of which were opened on April 15, 2024, comma, would be curtailed or taken away as an effect of the same. Full stop. Next para. Such rights have already accrued on April 15, 2024. Full stop. The respondent had full knowledge of the same. Full stop. Not only that, comma, the respondent participated in such fresh tender process, comma, thereby submitting itself to such process, and after turning out unsuccessful therein, comma, cannot be permitted to challenge the outcome of the tender at this belated stage, comma, for whatever reason. Full stop. Next para. Although the tenure of the contract of the respondent was deemed to be extended by virtue of the dice non-agreement for 2 years, comma, taking into consideration the COVID restrictions, comma, fact remains that the cause of action of the present challenge pertains to a tender which was opened on April 15, 2024, on which date the respondent was fully aware of the same. Full stop. Thus, comma, nothing prevented the respondent from making such a claim or assailing such tender at that juncture itself, comma, contemporaneously when the bid was open. Full stop. Next para. There are certain other facets of the matter as well, comma, such as the contract being by its very nature determinable, comma, which also entitles the respondent, comma, at best to compensation and not to seek a perpetuation of the contract, comma, on whatever ground. Full stop. Next para. In view of the above, comma, this court is of the opinion that the learned trial judge erred in law and in fact in granting the injunction passed in the impugned order. Full stop. Next para. Accordingly, the said order cannot be sustained. Full stop. Hence, comma, FMAT 130 of 2026 is admitted and allowed on contest, comma, thereby setting aside the impugned order bearing order number 3 dated February 16, 2026, passed by the learned judge, comma, 10th bench, comma, City Civil Court at Calcutta in miscellaneous case number 1556 of 2026. Full stop. Next para. Objection has been filed in the section 9 by them.
Instructions has not been filed.
Very good. It is made, consequentially, can 1 of 2026 is also dismissed. Can 1 or 2?
Can 1.
Can 1.
Dismissed.
Is also dismissed.
Dismissed.
Full stop. Next para. There will be no orders to cost. It is made clear that all the above observations are tentative in nature. Full stop. Neither the above findings nor the findings rendered by the learned trial judge in the impugned order shall be treated to be conclusive at any further stage of the proceeding.
Lord, can 1 could not have been dismissed, I guess, Lord, because the appeal has been allowed the stay. That was a stay application, Lord.
Oh, sorry. Disposal.
And Lord, there is a subsequent item number 9, Lord, FMAT 170. That's the extension order, Lord.
Last extension order.
As in view of the judgment passed in FMAT 130 of 2026, comma, FMAT, what is the number?
170.
170.
170.
170.
FMAT 170 of 2026 is also disposed of and abide by the judgment passed in the in FMAT 130 of 2026. Full stop. The impugned order, that is, what is the detail of the order? ওই মেমোটা কোথায়?
13th order, 18th May.
8th May 2026.
Order number 13.
Order number 13, my Lord.
13. That is order number 13 dated May 8, 2026. Passed in ওই যেটা বললাম আগেরটা একই ওই একই জাজ is also set aside.
Then my Lord, the order 39 rule for application also becomes infructuous. That order 39 rule for application for vacating, that also becomes infructuous, my Lord.
That will not say, you don't praise that.
ওটা তো কোনো মানে থাকে না।
We will not press that.
What?
What is the remedy? I said we will not press that. I'm so grateful, Milord. I'm so grateful. Great.
বই ফইগুলো আমাদের না তো এই বইটা আমাদের ঠিক আছে।
কোন জায়গায়?
For the appellant.
Yes.
This appeal arises, my lord, against an order of rejection of order 13, order 9, rule 13 of a application of a divorce suit, my lord. But kindly have a look into the
Order 9 to 13 rejected, why?
rejected, my lord, on the ground of limitation.
Take a seat.
Limitation.
You are for the respondent in this matter. Limitation.
Limitation. I'm wife, and
Only limitation.
yes, my lord, only limitation.
So
Service. The
did not file a section 5.
Section 5 is not that, my lord. The delayed application, my lord, on that ground, kindly have a look into the order. On that, the learned judge has said that the application filed in related stage after 2 years, my lord. Here, my lord, in there, my lord, decree of divorce passed on 9th November 2014. And my lord, the decree was handed over to me by my learned advocate in the court below in 125 on 19th December 2016. After 2 years, my lord. In the meantime,
They handed over or your advocate?
handed over. They handed over, my lord. I have received.
So you took a plea that you were not served with the summons.
Yes, my lord.
Is there any finding on that?
Yes. not served the summon.
If you are found to have been served with the summons, then
In application, I have not written, but the learned court has decided that newspaper publication. My lord, newspaper publication, I could not say anything in my application because there is no whisper in the decree. That is why, my lord, newspaper, they have published in a Bengali newspaper, but usually the wife is reading in English newspaper. And my lord, another thing is that they have, the learned judge has said that they
you are a Bengali. By
only wife, but she is not
no, not wife. We are not saying wife. By your, I mean, your language is Bengali.
This is Bengali, but she is usually reading English, knowing very well, fully
It's
well.
not a good one.
Ajkal Potrika, my lord. It is not widely circulated nowadays.
What is the name?
Ajkal.
Ajkal.
Ajkal. If it could be Anandabazar, then. And another thing is that he
Yes.
applied the number in 125, my lord, that the wrong number, the old number he has supplied. New number,
Of the suit.
Yes, madam. That is why she couldn't search. And
Yes.
stated that knowledge from 16, my lord, that in December,
When did you file this order 9/13?
order 9/13, I have filed in just few days after.
3 days.
3 days now.
3 days after.
Few days after.
In December 2016 itself.
Yes. 19th, 11th to
1912,
1912 to
2016.
and I have filed application 3rd January 2017. Few days after, my lord.
Very good.
My lord, kindly have
So let us see the findings of the.
Yes.
Mr. Chaturvedi, we should admit the this is a question of factor also involved. Summons and all.
125 also, they are not paying anything, my lord.
That will consider.
There is also one order.
That we appreciate, but with the this should be hard.
My lord, look at the application, my lord. We have received on 19th December.
Yes, after admitting the appeal, so we may refer the matter to mediation. You try to settle the disputes. If it fails, then we'll hear it out.
As my lord. If my lord is
Make some provisional payments and you see resolve it out in mediation.
only
You have remarried, Mr. Chaturvedi, your client.
Is it?
this was my remarriage.
These persons cannot.
Oh, that means
This was our remarriage. This was our remarriage.
no. As because they are not married, there is a chance.
100 times also.
Yes.
Second.
No,
second
only thing may I
Persons remarry more because the chances of aged persons remarry, young persons remarriage is difficult.
So there is a chance of reconciliation.
I haven't seen the client. Only 3 things, my lord, may I indicate.
Yes.
The first thing is, my lord, please take in that I have, my lord, furnished wrong number. Hence, she could not, my lord, locate the right number and file the written statement and contest. Now, my lord knows, my lord, suits are filed, my lord, before the learned district judge. But upon being, my lord, assigned to a learned additional district judge, my lord, it is renumbered. So at the relevant point of time, my lord, the number that was, my lord, it was supplied to in course of my filing written objection in the 125 proceeding.
No, at the 125 written objection stage, it had not been renumbered yet.
It has not.
It was renumbered, my lord.
When was it renumbered? What is the renumbering?
174 of 2013.
And
It is-
written objection filed?
Written objection that is not there in order. It is reflecting that at the time of filing the
If it was filed before 2013,
evidence he has said. My lord,
we
the-
want to know the time when it was filed. Before the renumbering or after the renumbering?
it is 28th April 2014. He has supplied the number.
Then
my lord,
Yes, and
you don't say then. It's our prerogative to say. Yes.
I'm tendering my
so
apologies.
the numbering,
He
my lord,
numbered
the written objection was furnished. The written objection was furnished with the old number.
So you say that at that point of time it was not renumbered.
Yes. Second thing, my lord, is that she is saying that I have used a wrong address and that the summons were served at the wrong address. My lord, the learned court, my lord, has dealt with it. I have used the address which she has used in her 125 proceeding. And my lord knows, my lord,
that the address used, my lord, in the collateral proceeding, if that is, my lord, used for service, then it is a good service. But the third point, my lord, taken by her, my lord, is that, my lord, her advocate, my lord, had although been served with the written summons, it was not communicated to her in the right time. That, my lord, is beyond me.
The advocate was given some. How could the advocate? How could she engage an advocate before getting some?
No. In the 125.
125 case.
125 was of which year? 13.
13. Now, my lord, there I have, my lord, exhibited the written, the plaint. So plaint was an exhibit there. So my learned friend, my lord,
No, that was done in 2014 itself.
14.
Written
Yes.
objection.
Yes.
And they filed it in 2017 January.
They filed in 2017. The suit was decreed in November 2014. So before that, my learned friend's client had all the occasion to have a copy of the plaint, to search it scrupulously and to get it.
So Miss case was pending independently at that point of that time.
No.
Miss case filed after the decree or before?
After the decree.
So when was the Miss case filed then?
Miss case was filed in 2017.
17. After getting the.
May I, my lord?
Sorry, not Miss. Sorry.
certified copy.
125. When
The
was
125, my lord. First of all,
the order 9 could not be filed during pendency.
Yes,
We are asking about the 125.
First 125 was filed.
That was before the suit. It was
Before the suit.
Oh, it was pending when the suit was decreed.
Yes. So, my lord, Miss case.
There you had given a copy of the plaint.
Yes, I have given a copy. It's, my lord, it's recorded. My lord, kindly see.
The written objection was filed before the decree suit was decreed.
Yes.
Written objection in the 125.
Yes.
Oh.
But kindly see, my lord, page 19. Ektu bole di ma.
Page 19.
Page 19, 19. Lord, kindly see, my lord, evidence adduced. Lord, kindly see the second paragraph of that heading. In course of examination of OP1, Lord, I am the OP1. The certified copy of gift deed, kindly ignore this. The certified copies of order sheets of mat suit number 2466 of 2013, this is the earlier number, was marked as Exhibit B, copy of the plaint. But kindly ignore written statement. There was no written statement. The written chief in mat suit. So my written chief, my plaint, these were all exhibited in the 125 proceeding.
So this is, you adduced evidence on which date? In 125?
But this is blood.
On Athas 20.
So unless you adduce evidence, there is no scope to know. Which date did you adduce evidence?
2014.
Just a minute. Yes.
Before that, I have given my written objection.
No,
On the basis of my written objection, I adduce evidence.
Yes.
And in the written objection, I have stated that, may I indicate the written objection? In the written objection, my lord, I have stated that this mat suit has been filed by me.
Now the question is, and in the evidence, the copy of the mat suit filed in the evidence.
The first I filed my written objection.
Yes.
There I tender the information that I have filed a mat suit.
Any question put in the cross-examination regarding knowledge of the mat suit?
Yes, yes. Then in this miss case, Order 9 Rule 13, there was again evidence. There she admitted.
Regarding her knowledge, okay, regarding the wife's knowledge about the suit. So when you filed the adduced evidence, the wife was in a position to know.
She came to know. She came to know when I filed my written objection, which was earlier to my adducing evidence. First I filed my pleading, then I adduce my evidence.
Yes.
So when I tender him my written objection, she comes to learn about it. Now, when she comes on dock in this miss case, she says that yes, in the 125 proceeding, in the written objection, from the written objection, I come to learn that a mat suit has been instituted against me by my husband. She admits that.
Anyway, that means without receipt of the summons, she did not appear. As because she did not receive any summons, she did not appear. This was a stand.
That is now enlarging the scope of inquiry of Order 9 Rule 13, because she says that I had knowledge. In so far,
summons not served very well.
No, summons were served by alternate mode.
Yes, but actual physical service not effected.
That's a
visual
different
service.
case.
But suit file, that knowledge was there.
Yes.
Although summons not received.
And why she did not receive? She says that I have been served, my wrong address was given. Now, which address is given? She gives in her evidence. In this case, she says that the same address is used, the one which I have used in my criminal proceedings. So what remains?
But in the impugned order, court does not find, does the court find these things that
Yes.
your written objection contained the
Yes.
Was that portion, Mr. Chaudhary?
My lord, may I?
Yes.
Lord, kindly.
Present impugned order.
Yes.
The application.
Lord, kindly sees, Lord, internal.
Yes.
And application kindly we will look into 20, page 20.
Internal?
Well, the internal page 3.
3.
Lord, kindly sees on careful evaluation of the petitioner's cross-examination. My lord has very kindly.
Is that we have seen?
She admitted that the address at which summons were issued was the one where she decided.
Let's the address. We are not on that. We are on the plaint being annexed to the written objection of the 125. You say the plaint of the suit was annexed in the 125 proceeding.
Yes, I have the written objection.
Or at least referred to.
I have the written objection.
So the court has to consider that. The court.
Lord, may I indicate that? May I indicate that? Lord, kindly sees.
Yes, in a cross, the very next paragraph to which you are reading after the bullet points in a cross-examination.
Yes, further in her own evidence contraries in her cross-examination dated 19th March 2018, she clearly acknowledged that her husband had mentioned the pendency of the divorce proceedings in the written objection.
Divorce proceeding in the previous number.
Previous number, if you search with the previous number, you get the new number.
That she could not, my lord. In 2014, my lord, he.
Let Mr. Chaudhary complete, then we'll come back. This is all, Mr. Chaudhary.
Yes. Now, Lord, may I?
So one in the 125, you disclose the pendency of the suit. Second, sub address was the same, 125 address. Anything else? These are.
And, my lord, in her evidence, my lord, in the miscase, Order 9 Rule 13, my lord, she admits all this. May I only?
Yes, that we have seen.
If my lord intends to see
the bullet points, we have seen.
Yes,
all containing the bullet points.
Yes,
we have seen only the bullet point.
If my lord intends to see, my lord, I am carrying the copies thereof.
A copy of the
evidence
so that she admits. Nepal Babu received
of the copy of the evidence, as well as, my lord, the fact that my plaint was a part of the written objection, and that in my written objection in 125 proceedings, I have stated the dates.
Stated, she has admitted. That's recorded. Yes. What do you say, Ms. White?
Sir, can you look into the application, my lord? The exact address was not given. I used to reside in Rajarhat in his flat.
Your 125, you have given an address.
Both the address he has given, but I used to reside in Rajarhat everywhere. My
125 application is your application, Ms. Maiti. You have given an address in your 125 application. He filed the suit and gave summons at that address.
After that, my lord, 125 application is Baripur address. 125 application is not there, my lord, with me. But the applications, my lord, kindly have a look into page 23 of my.
You have admitted in your evidence bullet points. See the bullet points at page 3, top of the impugned order. Sorry, of the impugned order. The very first bullet point. The real bullet for you.
Matrimonial suit never received.
Same address, Baripur. So you are discussing Baripur. It's written here. She had used the same address within bracket Baripur in the proceedings.
Never received and summoned in correct address. She further claims that husband deliberately suppressed the correct address of misleading him essentially.
No, we are saying page 3 of the impugned order, present impugned order. Page 3, top, the very first 4 bullet points. Please read those out.
125 CRP. She received judicial communication legal notice of address. She never contended those.
Same address used, judicial communications used to be received from that, legal notices received from that. Never contended you stayed elsewhere. You are a Bengali, widely circulated in a Bengali newspaper.
Both the address are written Rajarhat and Baripur.
Disclosed in 2014 about in the written objection about the suit in the old number. If you search the old number is Ms. Vice, please let us speak. Let us speak. We have to speak one sentence. Then you speak your sentences. They disclose the old number. As you know, old number pertains to district court. So if they disclose the old number, they must have disclosed it was before the district judge's court.
She could not find
there
out,
are
my lord.
no 2 numbers given to the same matter in the district judge's court for the same year. So if you just went to the district court and traced out that number, you would get the new number.
Yes, my lord, that is there.
That is
but
no pretext at all.
but
Your advocate was
my lord,
served.
kindly, the intention of the husband is so wrong, my lord, because he has given the old number in the year 2014.
Even then, you could
Even
just,
then, I couldn't search.
there are
it.
no
That is
two
my
numbers
fault.
of the same suit.
And application I have not written also, my lord. Only address point, my lord. I have looked into 20 page number 23 of my application, my lord. I have written all the address which is not matching with the
Your own address 125.
own address. One parent's address is Baruipur, and I used to reside in husband address, that is Rajarhat.
If your parents resided there, if you give that address in 125, if your parents got it, you won't get it.
Yes, they have not got it, my lord. Somehow he has managed, my lord. This is the fact.
No management.
We
Newspaper he has managed, court he has managed,
They have
then he has
managed-
managed Rashtra also. So we have this application.
No, my lord, kindly my lord,
No, no.
give a chance to the wife, because I have also, they have handed over on 19 December 2016, my lord. If I have knowledge, why they have handed over? My lord, I am putting this question to myself. They have handed over the degree to the learned lawyer of the appearing in 125. My lord, I have received copy. Page 12.
ভুল কি আছে অর্ডার ঠিক আছে সবই 2 বছর আগে পেয়ে গেছে ডিসমিস করে দেবো আর কি লর্ড অফ মিডিয়েশন জোর করে পাঠাবো দরকার ঠিক আছে না এটা মেইনটেনেবল
They handed over after that, immediately after that, we have filed application, my lord.
মিডিয়েশন এমনি
Previous knowledge, my lord, there is some foul play.
জোর করে মিডিয়েশনে পাঠাবেন যে এটা বাজে মামলাকে অ্যাডমিট করবো পেমেন্ট মামলার মেরিটে যখন কোর্ট ডিসাইড করে দেখতে যে নেই মেরিটে তখন সেটা শুধু মিডিয়েশনে পাঠাবার জন্য অ্যাডমিট করার কোনো মানে না এটা অদ্ভুত এক্সারসাইজ
We could not search out. It is our fault.
ম্যাট্রিমোনিয়াল রিলেশনশিপ হয়ে গেছে 2 বছর এর রাজি হবে চেষ্টা করে দেখুন বিয়ে থাকার পরে মতো করছি একজন করে
কত বয়স আপনাদের দুজনের? কত বয়স? হ্যাঁ, দুজনেরই কত বয়স?
Yes, Mr. Chaudhary, let us send it to mediation, have a chance.
Milord, kindly
Yes,
do
my
not,
lord, they
Milord,
take
why,
it
Milord, I
personally.
say this, Milord, now I inquired of my learned advocate. Milord, they are, Milord, they have crossed the age, Milord, of
Well,
being counsel.
you use your good office, both of you, and try to persuade the parties.
Cross the age of what? Mediation.
Cross the age of counseling. Milord,
Counseling, there is no age.
no, no.
Counseling with
The husband is now 76.
Very well.
The husband is 76. And
wife is?
Wife
So
is 62.
52 is in her affidavit is written 52.
No, 62.
If she wants to come back, you are 76, she is 50 to take her back.
No, Milord, I filed the suit on the ground of cruelty and desertion.
Very well. Now let there be an opportunity. Okay. You see, this is for the betterment of the society, for betterment of everybody.
We can't stand in the way, Milord, of my lord's directing mediation.
No, you
but
cannot direct mediation. You have to agree. Forcibly, you cannot trust.
My Milord, instructions are, Milord.
No, even no. Our request is this. Our suggestion is, if it fails, we'll decide the matter.
Kindly, Milord, excuse me, Milord, but my instructions are such, Milord, that
Do you want to come after vacation?
No.
Or with instructions?
No. My instructing advocate is present.
Unless you anyway.
After a long, Milord, after a long time, my learned junior colleague has come. He was, Milord, suffering from medical disability.
Who?
My learned advocate.
Oh, achha. He was suffering from, you have not seen him for a long.
Yes, yeah, my lord may not have seen him for long. I persuaded his son to send him because I was not seeing him. When this
Exactly,
case
right.
came, also papers were coming through his son. So I said, what happened to your father? He suffered a neurological disorder, and for past about 4 years, he was not available. I did not see him.
No, this is the best remedy actually to come to court.
Yes.
You're right.
Yes, Milord, because I find that there is nothing, Milord.
Nothing better.
Yes.
Whatever anxieties we have, when we come in court, and everything goes.
Yes. A sportsman has to hit the field.
Absolutely. Activeness. Yes, what do you say? Not on the sportsman aspect.
I'm so sorry, Milord. I get back to that all the time.
No, please do. Please do.
Give a chance to the wife to file written statement and contest. Because
No use of
is a
no use of
ground, my lord.
dragging this matter for so long. We don't find any error in the input there.
2016 I have got, my lord. If
2 years after
2016 and 2017, 1 month,
2014, it was served on your advocate.
my lord, that plaint was not served.
Plaint need not be served. You had knowledge of the suit.
That number only.
Number is sufficient. What else is required?
That could not be searched by that lady, by my lord. That is one of the grounds.
আছে লইয়াতে এই তাকে তো বলবে যে
কোনো wrong advice
It is also there.
chance নিয়েছে তারপর
No, in my application, it has not been written.
অ্যাপিয়ার করুন আদারওয়াইজ ইউ ফেস কনসিকুয়েন্সেস এই অ্যাডভাইসটাই দেয় এই তো যখন একটা ডেট ম্যারেজ কি 76 বছর বয়সে 62 নাকি 7 বছর জোর করে মিডিয়েশনে ঘাট ধরে আমি একদম ডিসকাস করি মিডিয়েশন কথাটা আছে বলে ওটা ম্যাজিক ওয়ার্ড হয়ে যাবে ওটাকে ইয়ে করছে এনকারেজ করতে করে করুক না সুপ্রিম কোর্ট এনকারেজ করলে আমরা তো জজ ইন আওয়ার ওন রাইটস আমাদের তো একটা বক্তব্য থাকবে না একটা ম্যাটার অ্যাডজুডিকেট করতে পারেন সেখানে মিডিয়েট
Expertly
কি এরর আছে ওর একটা বার কোনো একটা এরর আছে কিছুটা রং অ্যাডভাইস আছে এই ধরে নেওয়া যায় না ছোট কিছু ধরে নেওয়া নিয়ে করবে ওদের এই কন্ডাক্টটা দেখেই বোঝা যাচ্ছে বলে তো
Page 23, I have written all the addresses, my lord. There, my lord, it is differing. My
see it was served on your advocate you maintained we continued with the 125 proceeding with the same advocate no change of advocate
that learned advocate was served in the year 2016, my lord. Again and again.
no
Submit. Yes, my lord.
see
Kindly have a look into.
please come to the MP please come to the MP order page 3
Kindly have a look into page 12, my lord. That is received. And impugned order, it has been written. That is
let us see your evidence Ms. Maitri when the miscase the 125 is still pending
yes.
let us see your evidence evidence
Please give me my may I submit? They are not.
oh we want to see your evidence
At this point of time, their address could not be.
all right
touched by
finish
the
your
police.
sentence first show us the evidence you start from where you stopped you start from the mid sentence but first show us your evidence when a court asks you a question first meet that
Yes.
have you annexed the evidence
Yes. Yes, madam. Page 19.
page 19 page 19 of what
The application.
page 19 is the middle of an order
No, my lord, application. In the application, my lord, I have annexed all these things.
this is the application can one
Can one be annexer 1? Annexer A to middle of the order, my lord. Page 19.
we want to see your evidence Ms. Maiti
Evidence is not given. my lord.
what are you showing us
evidence
It is
দেয়
already
এখানে অ্যানেক্স করে
it's adduced.
have you got a copy of your evidence which you adduced in the order 9 rule 13
No, my
Oh,
lord.
magistrate.
It's not given.
Mr. Chaturvedi, have you got the copy of the evidence
I
their
have
evidence
the copy of the written objection. Lord, kindly, my lord, seize this, my lord, for a moment.
no there's a
Can
doubt Ms. Maiti is saying that the written objection itself was received in 2016
No, I am showing the date, hence I'm showing the date. This is, my lord, the written objection.
No objection. আমাদের কাছে নেই।
এটা ওনাকে দিন একবার Ms. Maiti order 9 rule 13 application have you annexed
Yes, my lord.
where is that
That is I'm showing, my lord. Page 23, my lord, of my application.
And this objection,
A3.
this objection is received on the 28th of August 2014, much before the decree is passed.
Yes, my lord.
Ms. Maiti let us see the have you annexed their written objection to order 9 rule 13
No,
why haven't you annexed their objection
but the objection is, my lord, a part of the document that I handed up to my lord.
Then we
This
can
is the annexure, my lord, to my written objection.
Mhm.
Lord, kindly see, this is the written objection.
Another copy.
Yes.
Paragraph 2 and 3, ma'am.
Miss case 93 is the miss is that
125 proceeding.
225 proceeding. On 124 বারুইপুরটা তো ওনারই অ্যাড্রেস।
Ms. Maiti, they have referred to this written objection in their objection to your order 9 rule 30.
It is annexed, my lord. I have
It is
indicated.
annexed. And that annexure shows that it was received in 2014 itself. Where do you get that you received it? Where have you stated that you received in 2016? Where do you get that from?
Next, sir, A1, page 12, my lord. The judgment was handed over to us on 19/12/2016. The number was given. I am not denying, my lord.
It was communicated to you.
Yes.
Have you annexed that communication letter? Where is that communication letter?
My lord. Page 12.
No. The ex parte judgment was communicated to you
Yes.
by the advocate.
Received.
Yes.
Lawyer has received.
Yes, your lawyer has
Yes,
received.
my
Where?
lord.
Which page?
Page 12.
Putting signature
With signature.
Judgment dated.
Dated.
I'm not denying that they have not supplied the number. But that is not enough.
2014 সালে তাতে সুটের কথাটা মেনশন করেছে। সুটের সাবসিস্টেন্সের কথাটা মেনশন করা আছে।
আচ্ছা, তাহলে
নলেজ
about the pendency of suit. আর
এটা
এখান থেকে কবে ফাইল করেছে?
এটা পরে
19/12 থেকে 16
জাজমেন্টের কপি
না, জাজমেন্টটা তো ঠিক আছে 19/12 তো না নলেজে আসবে জাজমেন্ট।
সুটের নলেজটা তো
I have knowledge in spite of what they have said.
রিটেন অবজেকশন এই ফাইল করেছে তাতে মেইনটেনেন্সের রিটেন অবজেকশনটা অ্যানেক্স করেছে যেটা কপি হ্যান্ড মেইনটেনেন্সের রিটেন অবজেকশনের যে কপিটা হ্যান্ড তাতে ও রিসিভ করেছে মেইনটেনেন্সের অবজেকশনটা 28/8/20
মেইনটেনেন্সের অবজেকশন
এবং মেইনটেনেন্সের অবজেকশনটা ভিতরে দেখুন এই সুটের কথাটা বলা আছে which paragraph of that maintenance application is referred to the suit? Have you got another copy of that maintenance objection?
Yes, my lord.
Which paragraph you have referred to that suit?
16.
My lord, kindly see
Paragraph 16.
16 of the objection.
I have no copy, but I have somehow
But
seen, my lord.
from the date of the decree. The কবে ডিগ্রি পাস হয়েছে?
16. That is
19/12
old number. I'm denying that they have not given number,
ডিগ্রিটা পাস
but the old number.
এবার ডিগ্রিটা
কবে
পাস হওয়ার 1 মাস পরে সেটা করতে হয়।
28/8/2014.
অবজেকশনটা রিসিভ করেছে অগাস্ট 2014
ওটা হলো ফর নট বিং প্রেজেন্ট when the in the suit। আর এই যে ডিলে ফর ফাইলিং দিস সেটা হলো এই 19/12/2016 তে ও রিসিভ করেছে। এটা হলো সেকশন 5 থেকে ও বাঁচাতে পারতো লোয়ার কোর্টে ট্রায়াল কোর্টে, কিন্তু কারণ অফ নট বিং প্রেজেন্ট সেটা হলো
ও যদি সুদ সম্বন্ধে ডিগ্রিটা হওয়ার আগে থেকে জানে বছর ডিগ্রি হওয়ার পর তখন সুটে
এখানে
খোঁজ নেবে
এখানে আছে ইন্ডিকেশনস কিছু আছে নট প্রপারলি অ্যাডভাইসড, তাকে প্রপারলি
অ্যাড্রেস কোথায় পাচ্ছেন
না ইন্ডিকেশনস অফ দ্য কন্ডাক্ট। এই যে
অর্ডিনারি কোথায় আছে
অর্ডিনারি রুল,
অ্যাপ্লিকেশনটা অ্যানেক্স করেছে
হ্যাঁ অর্ডিনারি রুলস বলছে এইটা পাওয়ার পর থেকে সেও
সেকশন 5 ফর
হ্যাঁ
যেটা আছে সেটা কোথায় আছে
সেকশন 5 এ
তারপর 23 তে আছে
পেজ
Page 24.
24 yes
Yes. Page
এই
24.
জায়গাটা পাবেন
Paragraph 4.
Page 24 paragraph 4
I have stated, and in my application also, paragraph 7.
এই যে ডিসক্লোজ করে
I have
এইটা পেয়েছে।
অ্যাডমিটই করছো
That means 2 years there was delay in filing. So
delay, but
when you from the date you receive, thereafter you file this setting
my lord.
aside.
That is my contention. Even if in 2024 they have supplied the old number, that is my contention. I am not denying that they have not supplied. I am saying that they have supplied the number.
certificate copy
Old number.
was supplied in
Yes.
2014
That
you said just now that it was supplied in 2016
2016 the certified copy. handed
Certified copy you could have yourself copied. You could have appeared in the suit.
If I have knowledge, full knowledge, my lord, they are
Full knowledge you did not apply. You wait for them to supply. Why should they supply?
that may be there, my lord.
2 years you don't take out any application. You merely contested that. Still you are proceeding with that
Paragraph
125.
I have stated, my lord, elaborately that, and about newspaper also I have stated.
Mr. Chaudhary, take further instruction whether it should go to mediation, let it appear before the regular bench. We request counsel for the parties to take, we request learned counsel for the appellant and learned senior counsel for the respondent to take instructions whether their clients are agreeable to go to mediation to settle their disputes. Let the matter be listed in the monthly list of June 2026. The copies we are returning back to you, Mr. Chaturvedi. On the next occasion, when we take up the matter, we'll take.
As well.
জুনের মধ্যে 15 days এর মধ্যে করতে পারবে কনসিলিয়েশন?
না 22 তারিখে পরে করবে।
হ্যাঁ, কম্বাইন্ড লিস্টে আসুন। 22 তারিখ পরে কম্বাইন্ড লিস্টে আসুন।
জুলাই মাসে।
জুন
তো আপনি তো অ্যাভেলেবল হবেন না।
লিস্টে থাকবে যদি আর্জেন্সি করে যদি আর্জেন্সি
Within these 15 days, can it be possible?
What? No, you take instruction whether you want to go to mediation, not mediation. Mediation, then you send it to mediation. Both sides have to agree.
Yes, ma'am.
Take further, Mr. Chaudhary will also take further instruction whether. Yes.
Lordship, in this matter, I'm praying for an accommodation.
No. Good.
Institute of Steel Development.
My lord, in this matter, I'm led by Mr. Shivshankar Banerjee. He was appearing an
You are there. Start the matter. What is the matter about?
My lord, we have prayed here for an ad interim order. We have come against.
Challenged an ad interim order.
Yes, my lord.
Injunction was granted
By the lower court.
Achha. What was the suit for?
There's a disciplinary proceeding against an employer, my lord.
You are the employee.
I'm the company, my lord.
You are the company. So disciplinary proceeding has been stayed. What injunction has been granted?
We have issued a show cause notice.
Yes.
Against that show cause notice, that employee has already
Injunction, not to give effect to that show cause.
My lord.
What was the ground for grant of the injunction? More or
My
less?
lord, we have repeatedly informed that employee the performance report was decreasing, but he was not taking care of this, so that is why
No,
we have.
what was the ground on which injunction was granted? Let us see the interim order once.
Details order লিখেছে।
Oh, this matter, different employee had come before us. Probably there is some order passed by us previously. It was a part of that bench. Let us check. Yes.
Disciplinary proceedings state.
In a different proceeding, a similar order was passed.
By the lower court, my lord.
No, by the High Court, probably. Let us see. Please come to internal page 3 of the interim order. Interim order. Internal page 3.
My lord.
See about 4 lines from the top. It also appears that the present show cause notice dated such and such has been issued to the plaintiff after passing of the order dated such and such passed by the High Court Calcutta, by which order date 12/2/2024 passed by the President and the Appellate Authority were considered, and it was directed that no coercive action. That was in respect of another employee of this concern itself.
Proceedings can continue, but no final order will pass.
তাই বলেছে?
Coercive action মানে তো তাই কোনো পেনাল্টি পাস টাস করা টরা এগুলো করা যাবে না উইদাউট লিভ অফ দ্য কোর্ট। এইটা কিন্তু এটা কি আপনাদের ডিভিশন বেঞ্চে হয়েছে?
না। হ্যাঁ, এখানে অর্ডার দিয়েছে নট টু গিভ এফেক্ট টু।
মানে ফার্দার প্রসিডিং আটকে হয়ে গেল। হাইকোর্টের অর্ডার ছিল মানে আপনার যদি বেঞ্চে রিপোর্টে আসবে, হ্যাঁ একটা চেনা লাগছে কারণ এই যে রুলসটা বলছে এইচআর ম্যানুয়াল 2022 নিয়ে একটা অ্যাডমিট করে সার্ভ করতে বলে অ্যাডমিট করে তাহলে এটাকে কোনো তখন ইয়ে করে অ্যাডমিট করে সার্ভ করতে বলে করছে দিয়ে দেওয়ার দরকার নেই অ্যাডমিট করে সার্ভ
You're admitting that.
My lord.
What is your name, please?
I'm the advocate on record, Sritapa Sinha. Sritapa Sinha.
Mr. Banerjee is in court.
My lord, actually, he is suffering from some issues, medical issues.
He has
So
left
after,
court.
yes, my lord.
Ms. Sritapa Sinha, appearing for the appellant submits that the impugned order suffers from several infirmities and places reliance on the annexures to the injunction application, on the strength of which such order was passed, was also referring to the relevant rules governing service of the concerned employee, that is the plaintiff stroke respondent. Full stop. Upon hearing learned counsel, we find sufficient arguable issues on facts and law having been raised in the appeal. Full stop. Accordingly, FMAT 147 of FMA 668 of 2026 is admitted and shall be heard on the grounds taken in the memorandum of appeal. Full stop. The appellant shall serve copies of the appellants shall serve a copy of copies of Can 1 of 2026 as well as of the memorandum of appeal on the respondent, indicating that the applications shall be listed for hearing in the monthly list of June 2026, when an affidavit of service to that effect shall be filed.
Grateful, your lordship.
Be your name only.
Fine.
Yes.
My lord, is my appeal. It is arising out of refusal of an ex parte ad interim order of injunction.
Right.
Suit for declaration, specific performance, and injunction, my lord. The admitted sale consideration I paid a
So you are the plaintiff.
I'm the plaintiff, my lord. It's been refused on one ground
Ad
alone.
interim refused.
Ad interim ex parte refused. There was no caveat. There still isn't any caveat. One ground, I must be candid, my lord. The suit property relates to DAG number 4631. The vendors have a Khatiyan number of 432. In my schedule, unfortunately, an additional 1 has gone down in the plaint. But there are documents on record and also a plaint. I annex a map containing the proper particulars, the agreements of which specific performance I seek for, provide the correct description. In my plaint body as well, I've correctly described it. This is the only ground on which the learned
Plaint
trial
schedule as well as the injunction application schedule wrongly mentioned.
it's been copy pasted, my lord. That's the wrong schedule which has gone down the learned trial court, my lord. You'll find it's a one-page order. My only prayer is, my lord, today the court could have put me on notice of this defect. My lord, instead the court has directed issuance of notice. Now the difficulty is if the defendants now receive notice of this application, immediately they'll take steps to alienate the property, my lord. I have also shown, my lord, there's a third party who's written to me informing that the defendants are looking for purchasing the property, or rather the defendant seeking to alienate the property. It's a one-page order.
Appeal has been preferred against an order whereby ad interim injunction was refused in the suit filed by the plaintiff stroke appellant for specific performance of an agreement. Full stop. Learned counsel for the appellant argues that although the correct description of the suit Khatiyan number appears from the agreement, which was produced before the learned trial judge, as well as from the pleadings in the body of the plaint and the injunction application, there was an error in transcribing the number of the Khatiyan in the schedules of the plaint and the injunction application, on which premise the ad interim order was refused, although notice of the injunction application was directed to be served. Full stop. Next para. Upon a perusal of the materials before us, we find substance in such contention. Full stop. Even otherwise, from the application for injunction and its averments, we find a prima facie case for grant of injunction as well as balance of convenience of inconvenience being in favor of such grant having been made out. Full stop. Accordingly, the respondents and their men and agents shall remain restrained by an order of injunction from doing what?
From alienating as well as my lord, parting with possession. My lord.
Let us see your prayer.
Yes, my lord, page 50 is my prayers in my stay application. It's a reproduction of the
Why stay application?
I'm sorry, my lord, injunction application.
It's written as stay application. It should not be
No,
so.
my lord, an application for injunction.
Injunction appropriate orders.
I don't know, in the matter of application for injunction.
You saw somewhere stay. Anyway,
Mm.
honest.
Alienating, transferring, and my lord, possession as well. It's with them. They have
From
possession.
alienating, selling, transferring, alienating, and or encumbering the suit property in favor of third parties, and or altering the nature and character of the suit property in any manner, comma, both till disposal of Can 1 of 2026, full stop. The appellant shall serve copies of the application as well as the memorandum of appeal on the respondents, indicating that the application shall next be listed for hearing in the monthly list of June 2026. The appellant shall file an affidavit of service to that effect on the returnable date.
My lord, where my lord has recorded my submission that in the body as well as the other, apart from other means documents annex, apart from the agreement and body, my lord, the documents I have includes a map containing the correct khate. If my lord will include
একটা জায়গায়
that as
কোথাও
well.
বলেছি যে ওই body of the plaint
Agreement.
না তার ঠিক আগে একটা এগ্রিমেন্টের কথা বলেছি ঠিক আছে এগ্রিমেন্ট agreement and
Other documents. A map is
Other
also there.
documents.
Other documents will suffice. Okay. Keep your place, right?
you have annexed all those here.
Yes, yes, everything is there.
The injunction
Whatever
itself
is
is annexed with the annex. Yes.
Okay.
Next.
Item number 70.
But see, I am for that.
I pay for the intervener. Can 2 and 3 are my applications.
You want to be added in as part.
Yes, can 2 is my intervention application to be added as a party.
What
and
is the
can-
application for?
Lordship application, Lordship, can one is
I
for
mean the main application.
main application for injunction?
By the impugned order, ad interim was refused.
No, yes, Lordship.
Ad interim was
Ad interim was
Shoot for?
shoot for declaration and injunction.
Why refused?
Lordship, kindly come to the impute order once. Second page of the impugned order, Lordship.
Who admitted the appeal? Not our bench.
Not.
When was
It was admitted, Lordship, on 7th day of February 2024 by Honorable Justice Showman Sen and Honorable Justice Uday Kumar Ban.
No proper admission order was recorded, but
Yes.
yeah, you can put it admission admission interim order দিয়েছো তো interim order দিয়েছো
তাহলে ধরতে হবে admission যেটা interim করে এটাই কন্টিনিউ করছি
Lordship, kindly come to the impugned order, Lordship.
Yes.
Yes. Second page of the impugned order, Lordship. Admittedly, the plaintiff petitioners are in possession of the suit premises since 1998, but the plaintiff petitioner has failed to make out prima facie case in order to get the ad interim order of injunction as paid for. Balance of convenience and inconvenience are in favor of the plaintiff petitioner, and I find no urgency in this matter. Accordingly, this application for order 13.
Produce your title deeds.
Yes, Lordship.
Who are you?
But I am. This
2 and 3 are separate persons.
No, 2 and 3 are
can 2 and 3?
Can 2 and 3 by the same person. Can 3 is for vacating of the interim order which has been passed by this court. And
You're rejecting can 2, so can 3 becomes infectious.
Lordship may allow can 2, so can 3 can.
Who are you? I mean,
This is a walk of property. This is a walk of property. I am the Mutawali. And
the Mutawali?
Yes, and this is also
they have admitted it's a walk of property.
They have produced the deed. The deed also records that it is a walk of property. It could not have been sold at all.
Have you been implemented as a party to the suit?
No, but I have filed an application for impletement that is also pending.
You have filed an application?
Yes, that is pending. I filed it in January 2026.
What is your say on the? What is your take on this?
Lordship, I want to file repetitivity in opposition. Lordship, take instruction from my client and against the can 2 and can 3, both the can.
We'll give you a short time for that. 1 week after the vacation, reply 1 week. We'll put it thereafter.
The deed itself shows it narrates Indenture of work-off and endowment.
No, we'll deal with that.
If possible, 2 weeks after vacation.
Why?
Because if we want to sit with our client and we'll be out of station for the vacation.
You will be out of station?
Yes.
From when to when?
From tomorrow.
Learned counsel for the appellant seeks to use affidavits in opposition to TO2, Can 2 of 2026.
2024.
2024.
No, 2026. I'm sorry.
2026 and Can 3 of 2026.
Yes.
So accordingly, the appellant shall file such affidavits by June 19, 2026. Push up reply if any 1 week or 2 weeks.
But 1 week.
Reply if any shall be filed. Reply thereto if any shall be replies thereto if any shall be filed by June 26, 2026. Push up the applications shall next be listed for hearing on June 29, 2026.
Lordship, ad interim order may finally be extended.
Ad interim order was still disposal of the application.
Still
No, it was
disposal of
extended
the
from time to time.
from time to time until further. It is extended until further order.
The ad interim injunction granted earlier. No, they have filed an application for vacating that also.
তাহলে
Should not extend it.
লিমিটেড পিরিয়ড থাকার কি
Until further order to the
তার মানে কি
let the interim order granted earlier stand extended till July 31, 2026 or until further order, whichever is earlier.
But one aspect of the matter, my lord, I have also attempted service on the actual defendant and the respondent. My lord, it has been returned that there is no such person in the address. Even they have not been able to serve the respondent.
Did you direct you to serve?
No, my lord, I have served the applications. Your lordship has
The
not.
applications are coming for the first time.
Yes.
You direct you that service cannot be looked into.
Very
Try
well. Your
efforts.
lordship may direct
In the meantime, the petitioners in Can 2 of 2026 and Can 2 of and 3 of 2026 shall serve copies of the said two applications on the on the respondent only one respondent indicating the next returnable date.
Grateful.
Because appellants are already there.
Yes.
So only on the respondent.
But even they could not serve them. There's no such. But our
First.
contention is a fictitious person. But well, we'll come back.
So if all the more entitled you to come on board.
Yes, well, that is. I am the actual sufferer. Grateful.
Deep. Item number 18, I appear for the appellant, my lord. Eviction decree suffered by me. Paper books directions have been given. Paper books are ready, my lord. My lord can post the matter for hearing, my lord. I will argue the matter. Only one thing, my lord. Execution matter is fixed.
1 second, Mr. Your respond numbers. You are for which respondents?
I am appearing for all the respondents.
6 to 11, 12, everyone.
Yes.
Please check up. One is a pro forma.
Not against the pro forma, but
apart from pro forma, all pro
All.
forma is necessary to serve. The
my lord, they are their own relatives.
nature of suit.
Eviction. Declaration eviction.
Pro forma was a co-defendant with you or what?
No.
they are
Pro forma defendants are their
Their people.
Yes, they are
Pro forma were dispensing with service of notice
Yes.
of death. Paper books are prepared, you said.
Paper books are prepared. I have it in my hand, my lord. Matter is fixed. Execution matter is 13th of June 2026. My lord will kindly fix after reopening any day before 30th of June, my lord, because
No, you are not enjoying any injunction order or
no injunction order. That's for that reason.
used.
But
The order is 18th January
my lord, kindly,
2026.
I'm showing it. Wait.
My lord, that order has been written that will abide by the result of the rule. We are not granting any stay.
No, where is that? Where is that?
That is in the
18th
paper.
January 2022.
Yes.
18th
My lord.
January 2022.
22.
That's 246 of my
My
paper
lord,
book.
Can 3 was disposed of. By disposing of said application, my lord, the prayer for injunction
Yes.
was refused.
Yes. I don't deny it. Sir.
28 January.
18.
18 January
18 January.
2026.
For the লেখা আছে কোথাও?
On the basis of.
We took up a point which was not urged before the honorable trial court.
There was
That
no
the property
pleading of
got vested with the state government. State government is the owner, and the state government gave me ownership of the property. That was the point.
Never wasted.
We will show documents. That's the point. We will argue in the
There was no
and we have
pleading at
also
all.
taken steps for filing of an amendment application of the written stay because
In
that
the
was not.
meantime, if this execution is carried
My
out,
lord, the execution has
Yes.
been directed
Yes.
18 June. 18
Kindly,
January
that's for
order.
that reason we have taken out an application right now
My lord, he
for
never
Jan 5 of
pleaded me. Now,
2026
my lord, he is.
for an interim protection, my lord. We are ready to follow the
Counsel for the parties submit that the appeal is otherwise ready for hearing. Footstep accordingly, let the same be placed in the list for hearing, placed in the monthly list of June 2026 for hearing.
And in the meantime, my lord, interim protection, I will pay an occupational charges, my lord.
now
If
see, we have to go to Supreme Court to get that varied.
yes, sir.
We are powerless.
কত তারিখ না আগে রেখে দিচ্ছে জুনে রেখে দিচ্ছে if some priority is given my lord
June appearance in the June list is priority.
And you see, matter is sub judice, the trial court will not proceed now.
if that
Quite a high priority because we are not adding at all.
if that observation is recorded then I am safe, otherwise they have said bring an order from the high court, otherwise we will proceed. That's
This is the order that it will appear in the list.
This is order.
Next man.
Please sir.
In view of the appearance of respondents through counsel, service on the respondents is dispensed with. The office report in that regard, in respect of non-deposit of Talabana, becomes redundant. Service of notice of the appeal on the pro forma respondent number 12 is dispensed with. Item number 19. 19 you were appearing
for the appellant petition,
Yes.
My lord, on the last occasion, I sought time for
Yes.
filing substitution application.
Misplace the affidavit.
Yes, yes. My lord, only affidavit of service is available, test out. But
The
other,
rest of the briefs has not been traced out.
I took it from soft copy, my lord. I have prepared all the applications, that is CAN 1, CAN 2, and CAN.
So the original affidavit of service is not there.
Yes, yes.
What's it? Everything
Yes,
is there.
It is with me. That I am filing to the my lord.
You are
Yeah,
enjoying any interim order?
No, my lord, there is no interim order. Earlier, my lord, earlier occasion, all the respondents were served, my lord. 7 except this is respondent, my lord. I have, my lord, substituted the years of the respondent number 8, and they have been served, my lord. They have received it. So, my lord, one is section 5. It is first of it, my lord. In the partition suit, preliminary decree has been passed, my lord.
Usual order.
Yes, sir. And injunction application is there for the reason, my lord.
Section 5, what is the delay, Mr. Baba?
Yes, my lord. Delay is, my lord, of
708.
Yes, yes, my lord.
You have served on the others were served.
Yes, yes. Earlier it was served.
What have you served? The section 5 or the stay also?
Section 5, and stay, my lord.
Both.
And that is filed with the
affidavit of service filed today be kept on record. So despite service, neither the substituted respondents nor the original respondents appear. What is the ground in section 5?
That the certified copy was given after passing of the decree, my lord, by the clerk of the learned advocate appearing in the trial court, my lord. I have, my lord, stated in paragraph 8, my lord, 8 onwards.
We find from the
8, 9, 10, and 11.
We find from the averments made in the condonation application that sufficient and plausible explanation for the condonation for the delay has been made out.
708 days.
Accordingly, we are not mentioning that. That would sound bad.
Oh, sorry. Yes, it is.
Because
It will be
708
helpful for
in
it
one
is-
sentence should not have been done.
Yes.
If the other side was here, you would face some difficulty. বেশি থাকলে লেখা না লেখাই ভালো যত কম লেখা accordingly can 1 of 2025 is allowed, thereby condoning the delay in preferring FAT 249 of 2025 no address to cost. Since the appeal arises out of a preliminary degree of partition, we direct the learned trial judge to continue with the final degree proceedings. However, no final degree shall be drawn up till disposal of the appeal without the prior leave of this court. CAN 2 of 2026. This was CAN 3.
CAN 2. Substitution is CAN 3, my lord.
CAN 2 is
Section 5
counts
is
as an
there.
injunction application.
Injunction application is CAN 2.
Have you asked for injunction also?
Yes, yes, my lord. So that
without the prior leave of this court. Next para. From the averments made in CAN 2 of 2025, sufficient prima facie case for grant of injunction has been made out. Also, it transpires that unless an injunction is passed, the appeal may be rendered infructuous. Hence, the respondents and or the men and agents shall remain restrained possession, Mr. Bhagat, we are not granting injunction.
But they are disturbing my position after passing of this decree, my lord. On the strength of this decree, my lord.
Don't know what your position is.
No, whatever I am positioning today, my
No,
lord.
that will be a vague order.
But my lord, it is, averment has been made, my lord.
Is there any finding in the trial court's
No,
judgment
there is
that
no
you are in
finding, my lord.
possession?
Whatever, my lord.
It's a partition suit.
Yes,
You are
sir.
the plaintiff. You are the defendant.
I know, I am the plaintiff.
Oh, you are the plaintiff. You are
My
challenging the
suit has-
suit has been dismissed.
No, suit has been partially allowed without, our claim was not, recognized to the whole extent. Only partially our share has been recognized, my lord. That is the decree. And this is my dwelling house, my lord, wherein this property has not been given.
So how can you pass an injunction without knowing whether you are in possession?
Status quo, my lord, as on today, my lord.
Status quo is equally bad, worse. Without
what is-
ascertaining, we are day in and day out, we are
My
deprecating
lord,
trial.
my lord, specifically, that is at paragraph 8, my lord, that is the dwelling house, that is plot number 137 and 138, my lord. They are disturbing us. So I have made this application, my lord. Paragraph 8. I have categorically stated.
In the impute judgment, is there any indication as to possession?
No, they have, my lord, did not recognize our share even. We have produced all the deeds, purchase deeds.
But how do you know you are in possession?
My lord, that cannot be ascertained without evidence. And there is no observation by the learned trial court as well in the judgment. my lord.
ক্যান টুটা কি শুরু করেছি কি বললাম না হ্যাঁ স্যার আগে কি বলেছি এর থেকে কেটে দাও তার আগে বলুন since the respondents choose not to appear nor file any affidavit in opposition to the injunction application, the averments made in the same are accepted by application of the doctrine of non-traverse. Accordingly, the respondents and their men and agents shall remain restrained by an order of injunction from disturbing the possession of the petitioners in respect of the occupied portion of the petitioners of the suit property till disposal of the appeal. The appellants shall put in postal costs and requisites for service of notice of the appeal on the respondents by June 12, 2026. This trial court record shall be brought by special messenger at the cost of the appellant. Appellants also to be deposited by June 12, 2026. The trial court shall be entitled to retain skeletal records in order to continue with the final degree proceedings. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention for enlistment mention the appeal for enlistment as and when the same is ready for hearing.
Then can 3. Can 3
What
is
is
to
can
be
3?
Substitution application. Substitution of respondent number 8, my lord. Heirs of the respondent number 8 has been, my lord, served with all the can 1, can 2, and can 3. I have filed this
Can 3 টা আগে করে দিও তাহলে সবকিছুর আগে ওই despite service none appears for the parties for it. Why such long delay? 1015 days?
My lord, because the after passing of the decree, the clients were not informed by the, my lord, learned advocate as well as this clerk, my lord, that I have stated in the, my lord, section 5 application. So there is such
From the averments made in can 3 of 2026, it transpires that the respondent number 8 has died, leaving behind 2 heirs and legal representatives. Next para. The explanation sought to be given for the delay in making the same is that the appellants did not have knowledge of the said demise till immediately prior to the filing of the application. Next para. You have not given the addresses of the heirs.
Yes, I have given the address, my lord, in the
Only
cost
the
title.
names you have given. Cost title you have
Yes, given,
Acha.
my lord. Then they are the son and wife. Same address, my lord.
Since the application is in, you have written major and sui juris, so they have written those things.
Yes, probably I written, my lord. Written.
Yes. Since the application is otherwise informed, comma, this can 3 of 2026 is allowed, comma, thereby directing the heirs and legal representatives of the deceased respondent number 8, Ramdhan Mahata, comma, as described in the cost title of the present application as respondents in the appeal in place and state of the said deceased on condonation of, after setting aside abatement on condonation of delay. Full stop. The learned advocate and record for the appellant shall carry out the necessary rectification in the cost title of the memorandum of appeal consequentially. No rest to cost. Please ask your learned.
Yes, I'm asking. If it didn't record.
Name.
English. সুব্রত থাকলো
আচ্ছা ঠিক আছে সাড়ে চারটে সময় তো খবর রেডি ওটার পরে আর
তারপর আর কি Yes. Respondent.
The police
You're suffering any order?
No, my lord, we have got a decree, my lord, for eviction of my lord, of a trespasser. Their case was their tenant. Naturally, no document proof. Trespasser. Yesterday was the date fixed for hearing of the my lord police help application. Order will be passed.
None appears for the appellant at the time of call, although the respondents are represented by counsel. So let the matter stand adjourned for the day. Day means after.
This is the video of service and
21, my lord, I am appearing on behalf of the respondent.
Right.
And this is can 2 is a condonation of delay application. There is a delay of 3 days. Ground section. This is an appeal under section 9 of the Family Courts Act, and the due to the ensuing puja vacation as well as the date of handing over of the
Yes, 3 days delay we are condoning.
My lord, can you record that we have raised objection? I won't stand in that way, my lord.
Vehemently raised objection and all.
My lord.
Learned counsel for the appellant places reliance on the averments made in the condonation application to seek condonation of such delay, which of the delay is of about 3 years, 3 days.
3 days, madam.
Next para, learned counsel for the respondent opposes such prayer, which of however, comma, on a perusal of the averments made in the condonation application, the court is satisfied that sufficient cause for the delay has been made out. Hence, can 2 of 2026 is allowed on contest, thereby condoning the delay in preferring FA 8 of 2026. The said appeal be deemed to stand admitted and registered and admitted. What is the other application?
The other application is for application and order for 2027 because 2 documents, orders
will be had along with the appeal. They'll file their
This copies be served. Copies be served. We have not been served the copies of these other application or the appeal.
Appeal is against what?
Appeal is against refusal of the trial court granting divorce on the ground of cruelty.
Copies have not been served.
No, my lord.
Affidavit of service I have handed over.
No, the application, the section 5 has been served, but the copies of the other appeals and the applications, they might be served, my lord, on us.
Can one? I will serve again, but it has been served, my lord. I'm told it has.
Although the copy of the application, copies of the applications have apparently been served, comma, which is evident from the receipt. Which comma, since learned counsel for the respondent submits that he is not equipped with a copy of the application, comma, let a copy of can 1 of 2025 be served afresh on the respondent, full stop, on the learned advocate for the respondent, full stop, next para. By its very nature, comma, the application. No. This is appropriate orders.
Kindly sees the prayer. The appropriate order is, my lord, but in the prayers, my lord, by utilizing powers and dispense with paper books.
Achha na, by এটা না করে sentence reframe করে দিচ্ছেন. In can 1 of 2025, comma, the appellant has made a dual prayer of early disposal of the appeal as well as for production of additional evidence. Full stop, next para, by its very nature, comma, the component of production of additional evidence is required to be heard along with the appeal. Full stop, accordingly, can 1 of 2025 shall be heard along with the appeal. Full stop, affidavits, if any, be exchanged in the meantime. So next para, in view of the appearance of the respondent through her learned advocate, comma, service of notice of the appeal is dispensed with, and the appeal be treated to be ready as regards service. The appellant shall put in the trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited within June 12, 2026. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records and learned advocate for the appellant. Liberty to mention the appeal for final hearing for enlistment as and when the same is ready for hearing. Are both of you agreeable to mediation in this?
Perhaps not 7
My lord,
years.
I have, my lord,
7
years there
I
residing.
have to,
No, mediation may mean both ways. You may
My lord,
decide to
if
part
they-
ways
my
also.
my lord, in that case,
Yes,
I have to seek instructions, my lord. I have to seek
learned
instructions.
counsel for the
my lord,
instruction when you
Respondent. Tomorrow, my lord, I can come back tomorrow itself.
tomorrow you won't be able to come back to this bench. Acha,
My lord,
the parties shall be at liberty to take recourse to mediation by approaching
lord.
the High Court Mediation Committee. In the event they so deem fit.
my lord, only one prayer, my lord. I have attached all documents. The paper book preparation can it be because the can 1 contains certified copies of everything.
You in the paper book you annex everything. The application log stock better.
But I have attached everything in can 1 also because this will take substantial time.
No, without paper book, it becomes difficult. Okay.
You are saying paper book. Oh, acha.
Dispense with the paper.
No.
Very well.
The paper.
Very well.
All of us have to be. I mean, all the documents need to be in a place.
All are there in can 1. Still, my lord, I will just very well. Great.
Item number 22.
Having led by Mr. Singh, my lord. My lord, we have served, my lord. Last occasion, wishing to serve, my lord, we have
My
served.
lord, I beg to appear on behalf of the appellant, my lord,
Yes.
virtually. My lord, this is my lord, Act 39 case, probate case, my lord, was dismissed, my lord, where my lord, the court ultimately disbelieved the case made out by
What is the application for? Application?
the application for
Injunction.
stay, my lord, because my lord,
Injunction.
the properties are now being dealt with, my lord. There is a
Yes, we are granting the injunction. Go better, you are applying for the other side.
Your lordship, I am.
You are at a loss.
This is an apprehension, my lord. There is an apprehension.
Your lordship, I appeared on behalf of the two respondents.
Which two?
Jayanti Sil and Shobita Gupta by filing Vakalatnama and pray.
Have you got a copy of the applications?
Yeah.
What?
Yes, your lordship.
They received, my lord. They received.
I received. And actually,
Received.
I pray
That
for.
in view of appearance, comma, service of notice on the respond numbers 4 and 5 is dispensed with. Full stop. The appellant shall serve.
Your lordship.
The appellant shall serve copies of Can 1 of 2026 on respondent numbers 1 to 4,
My lord,
1
we
to
have
3.
Already served, my lord.
Your lordship, I
On the
pray
caveat.
for
They were on caveat, my lord. So therefore, we have served, my lord.
your lordship, I pray for the release of this case in this honorable bench due to personal reason of the advocate of the respondent, Mr. Devashish Bhattacharya.
Who is Devashish Bhattacharya?
The advocate of the respondent.
Who is he? My relative?
Yeah.
Devashish Bhattacharya? Who is
Yes,
Devashish Bhattacharya?
yes, my lordship.
I don't know any Devashish Bhattacharya. I couldn't recollect any Devashish Bhattacharya. All Bhattacharyas are not my relatives.
No,
প্রথমবার শুনছি এটা।
Devashish Bhattacharya, High Court, Calcutta. I don't know any Devashish Bhattacharya. Sorry. Definitely not. Please continue with the order. কোথায় ছাড়লাম? না ওটা ভুলে গেছি। পুরো কেটে দাও। From the affidavit of service filed in court today, it transpires that service has been effected on all the respondents. Full stop. Next para. However, comma, next para, same para. However, comma, only the respondent numbers 4 and 5 are represented through counsel. Full stop. The appeal arises out of the dismissal of a probate application. Full stop. Next para. Since arguable questions of fact and law are involved in the appeal, we find sufficient prima facie case for grant of injunction. Accordingly, the respondents and their men and agents shall remain restrained from selling, transferring, alienating, and/or encumbering the suit property, subject property in favor of third parties in any manner till disposal of the appeal. Push up the
My lord,
there will be no orders to cost. The appellant shall serve. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondents by June 12, 2026. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within June 12, 2026. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice. Usual time. Parable of the trial court records and the learned advocate for the appellant. Liberty to the parties. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Next.
DP acknowledgement. DP
Well, I'm for the it's an appeal against a decree passed under Section 13 of the Hindu Marriage Act. The decree of divorce
Passed. What is his application for?
An application is for the stay, my lord.
Stay we don't grant, we'll grant injunction.
Well, injunction, my lord, on this. Is so that, my lord, it can be protected.
Yes. That also you have prayed in.
Yes,
the appeal arises out of a divorce decree, full stop. Since the parties shall suffer irreparable injury unless an injunction is granted, full stop, we restrain the respondent is restrained by an order of injunction from contracting any remarriage, comma, if not already contracted, comma, till disposal of the application. The appellant shall serve a copy of Can 1 of 2026 on the respondent, indicating that the application shall next be listed in the monthly list of June 2026. The appellant shall file an affidavit of service to that effect on the returnable date.
Admission of appeal, so for that on the next.
First appeal, admission is not. It's automatic admission. First appeal. Registered dream kora hoy amader court register admit korche.
Admission order is not in.
Here. Time shift for.
I'm appearing on behalf of the respondent.
My lord, I'm led by Mr.
16.
Is it you who convinced us that this is a short matter?
No. Mr. Roy. Learned advocate.
Mr.
Parthapatim Roy.
Not finding
My lord, want him here. Yes.
My lord,
Where is Mr. Rai?
see, he left me not. I'm reading my
paper
Mr. Parthapatim Roy.
Creation.
He left.
Let me find the paper books.
We take back. We will take it up after the vacation. No question of taking up this appeal now in this bench.
My lord,
14 minutes left. Broken bench will take up a first appeal hearing.
My lord,
Appeal hearing.
can we
we
find
are
the paper
suffering
books?
from an interim order, my lord. Well, we are suffering from an interim.
We have already
There
served
are counsel for the we are for the appellant.
this is my appeal.
For the appellant submits that the paper books are ready. Full stop.
We have served them already.
Paper books are
Yes,
ready and have been exchanged between the parties. Full stop. Due to paucity of time, the matter cannot be taken up for hearing today. Full stop. Accordingly, let the matter stand adjourned and be listed in the monthly list of June 2026. Full stop. The appellant shall file paper books on the next date when the appeal is taken up for hearing.
My lord, can be a date be fixed, my lord? For
কিসের extension? Hearing হবে? চলো।
চেম্বারে যাবেন না একদম এখানে?
আপনি দেখি যেতে যেতে চিন্তা করি।